All right, everybody. I think we are live. For some reason, my camera appears to have glitched out. How? Stupid. Weird. In 1 second, as soon as we start, we get camera difficulties. All right, there we go. Okay, we're back in the game, folks. All right, awesome. Hey, Scotty. Hey, Viren. Good to see you all. Good to see you all. Sorry, we had a bit of a camera issue, but we got her fixed. Awesome, possum. All right. So today we're going over Gundy versus United States, and we're going over more specifically. That's weird. More specifically, we're going over Justice Gorsuch's kind of the birth of what he calls the non-delegation doctrine. I have a little bit of an underlying game going on. It's not as good as Ryan's. It's not as good as Sean, potentially criminals, but I can underline important parts like that as we go along. We'll see how it goes. Hey, Chapingo, how you doing, brother? Good to see you in here. Good to see you. All right. So to talk about non-delegation doctrine off the top of the bat, right? The idea is essentially that when you have separation of powers, you have the idea that there's a legislative branch, the executive branch, and the judicial branch. The legislative branch's job is to make laws. Oh, that's the problem. My camera's not the right camera. What the Sigma? Hang on 1 second, folks. Jesus, Moses, God. That's why the angle's all weird. What the actual hell? Where is Rastlin? I know. I have no idea. Hang on, people. Just 1 second. More technical difficulty. I guess we're going to do this way. For some reason, my webcam just decided to take a crap on me. So, hey, Ukulele, hey, everybody. All right. I know, right? That's my whole. Yeah, I do it for the viewers. So we're gonna go with this weird camera angle today. I don't know what the hell happened to my webcam. That just decided to die on me. Anyways, it doesn't really matter for the analysis. Okay. So I was talking about before. So non-delegation doctrine is the idea that there are the three separate branches of government, and one branch of the government cannot delegate to another branch its powers. In this case, particularly, the executive branch makes the laws. The executive branch can't, under Gorsuch's reading, delegate the ability to make laws or rule setting, right, to another branch. In this case, as we'll see, I think it's a beautiful piece of legal writing. So we'll read the vast majority of the dissent, if not all of it, and go over the arguments that are made. But the argument that Gorsuch makes here in the big scope is that the legislative branch can't leave an open-ended law and say, we should make a law that the attorney general should enforce it however they want. That's not actually setting a law the way it's supposed to be done. The executive branch has the power to enforce the laws which the legislature passes. The legislature can't then delegate its authority to the executive branch to make the laws itself. This is where Gorsuch comes into conflict with what the majority opinion here holds. All right. So we'll start reading it and we'll go through what the legal arguments are as we go. The Constitution promises that not only the people's elected representatives may adopt new federal laws restricting liberty, yet the statute before us scrambles that design. It purports to endow the nation's chief prosecutor with the power to write his own criminal code, governing the lives of 500,000 citizens. Yes, those affected are some of the least popular among us. Oh, so maybe background on the case first, actually. So Gundy is a sex offender. The question that is actually in play here is whether or not a statute, and we'll get into that in his analysis, but a statute that allows the Attorney General to set rules for sex offenders' registrations, even for those who were registered as sex offenders prior to the act being passed. Now, that's what's called a post facto law. And so the idea that, and this is part of the Constitution, it's one of the biggest things the framers worked at, is there are no laws under the framing of the Constitution that can affect people that committed the crime before it was passed. So that's one of the things that comes into play here too, is that this, by not passing a law that actually goes into effect on people who committed the crime before the law was passed, but allowing the Attorney General specific powers to do the same thing. But it's not Congress is doing it, so it gets around that constitutional loophole. That's the problem here. So this affects sex offenders who did not register or had different registration requirements before and after the statute in question was passed. All right. So yes, those affected are some of the least popular among us, but if a single executive branch official can write laws restricting the liberty of this group of persons, what does that mean for the next? Again, if you allow this strand of jurisprudence to go forward, it could be anybody next. It could be J6ers. It could be parents at PTA meetings. It could be any other group of people that if the Attorney General has power to enact a law over them, there would be a problem with that. Today, the plurality of an 8-member court endorses this extra constitutional arrangement, but resolves nothing. Working from an understanding of the Constitution at war with its text and history, the plurality reimagines the terms of the statute before us and insists there is nothing wrong with Congress handing off so much power to the Attorney General. And then he kind of throws some shade at Alito here, but Justice Alito supplies the fifth vote for Shade's judgment, but does not concur or join in any of the plurality's constitutional or statutory analysis, indicating instead he remains willing in a future case with a full court to forbid these matters. I respectfully would not wait. All right. For the individuals, convicted sex offenders, after Congress adopted the Sex Offender Registration and Notification Act, SORNA, in 2006, the statutes offer detailed instructions. It requires them to, quote, provide state governments with and update information, such as names and current addresses for inclusion on state and federal sex offender registries. The law divides the offenders into 3 tiers based on the seriousness of their crimes. Some must register for 15 years, others for 25 years, and so others for life. The statute proceeds to set registration deadlines. Offenders sentenced to prison must register before they're released, while others must register within 3 business days after sentencing. The statute explains when and how offenders must update their registrations, and the statute specifies particular penalties for failing to comply with its commands. On and on the statute goes for more than 20 pages of the U.S. Code. I pulled it up. It is quite a long bit of code. All right. But what about those convicted of a sex offenses before the act's adoption? Again, this would be called ex post facto law. If you commit a crime that's not a crime until it is actually made a crime by law, then the way the constitutional framework is set up, then you can't be charged with that crime. So at the time of SORNA's enactment, the nation's population of sex offenders exceeded 500,000, and Congress concluded that something had to be done about these pre-act offenders too. But it seems that Congress couldn't agree what that should be. The treatment of pre-act offenders provided a controversial issue with major policy significance and practical ramifications for the states. This is from the judicial history of the bill. Among other things, applying SORNA immediately to this group threatened to impose unpopular and costly burdens on the states and localities by forcing them to adopt or overhaul their own sex offender registration schemes. So again, part of the reason that this didn't happen so much that the Congress considered was that each state under SORNA, rather under the pre-existing structure before SORNA, was allowed to set up their own scheme for registering sex offenders. So we have a federalism issue here too. The federal law said states can make their own schemes, and the states had implemented them. And if SORNA were to go into effect like that, then all of a sudden, all the states would have to redo all of their state-level sex offender registrations to go ahead and comply with the federal law. Congress didn't want to do that, so it simply passed the problem off to the Attorney General for 500,000 pre-act offenders. The law says only this, and that's 34 U.S.C. 2091 3D. Quote, the Attorney General shall have the authority to specify the applicability of the requirements of the subchapter to sex offenders convicted before the enactment of this chapter and to prescribe rules for the registration of any such sex offender. Yes, that's it. The breadth of the authority of Congress granted to the Attorney General in these few words can only be described as vast. As the Department of Justice itself acknowledged, SORNA, quote, does not require the Attorney General to impose registration requirements on pre-act offenders within a certain time frame or by a date certain. It does not require him to act at all. The Attorney General does not choose to act. He can require all pre-act offenders to register, or he can require some, but not all to register. For those who he requires to register, the Attorney General may impose some, but not all of SORNA's registration requirements, as he pleases. And he's free to change his mind on any of these matters at any given time or over the course of different political administrations. So we can already see the problem that's brewing here, right? If the entire enforcement of the law is only to the discretion of the Attorney General, and the Attorney General can not only decide who the law applies to, but also which aspects of the law apply, what the time frames are for complying with those aspects, as well as that the Attorney General can change between administrations. And so what the Attorney General might want people to do could change. And that's exactly what happened. Congress thus gave the Attorney General free rein to write the rules for virtually the entire existing sex offender population in the country, a situation that promised to persist for years or decades until either the pre-offenders passed away or fulfilled the terms of the registration obligations and post-act offenders came to predominate. Unsurprisingly, different Attorney Generals have exercised their discretion in different ways. For 6 months after SORNA's enactment, Attorney General Gonzalez left the past offenders alone. Then the pendulum swung the other way, when the Department of Justice issued an interim rule requiring pre-act offenders to follow all the same rules as post-act offenders. A year later, the Attorney General Musaki issued more new guidelines, and this time directing states to register some, but not all of past offenders. 3 years after that, Attorney General Holder required the states to register only those pre-act offenders convicted of a new felony under after SORNA's enactment. Various attorney generals have also taken different positions on whether pre-act offenders might be entitled to credit for time spent in the community before SORNA was enacted. These unbounded policy choices have profound consequences for the people they affect. Take our case before us. Herman Gundy pleaded guilty in 2005 to a sexual offense. After his release from prison 5 years later, he was arrested again, this time for failing to register as a sex offender, according to the rules the Attorney General had then prescribed for pre-act offenders. As a result, Mr. Gundy faced an additional 10-year prison term, 10 years more than if the Attorney General had, in his discretion, chosen to write the rules differently. So basically, the crime that he's being convicted of here, this second additional penalty for failing to register, which is a 10-year federal felony, changed because the rules changed because the Attorney General changed. 2. Our founding document begins with by declaring, we the people ordain and establish this Constitution. At that time, this was a radical claim, an assertion that sovereignty belongs not to a person or institution or class, but to the whole of the people. From that premise, the Constitution proceeded to vest the authority to exercise different aspects of the people's sovereign power in distinct entities. In Article 1, the Constitution entrusted all federal government's legislative power to Congress. In Article 2, it assigned the executive power to the president. In Article 3, it gave independent judges the task of applying laws to cases and controversies. To the framers, each of these vested powers had a distinct context. When it came to legislative power, the framers understood it meant to mean the power to adopt generally applicable rules of conduct governing future actions, not past actions, by private persons. The power to prescribe rules by which the duties and rights of every citizen are to be regulated, and the power to prescribe general rules on the government and on society. The framers understood, too, it would frustrate the system of government ordained by the Constitution if Congress could merely announce vague aspirations and then assign others the responsibility of adopting legislation to realize its goals. An example of this would be if Congress to come up with like the Do Good Stuff Act and say all executive bodies, all executive agencies must do good stuff. And then what that means or what those actions are would only matter in the context of what that agency thought it was. So the Pass Do Good Stuff Act would violate the non-delegation principle and would violate the basic premise of separation of powers of the Constitution. Because again, Congress can't delegate its authority away to the executive branch and say, we don't know what we're going to say, do good things, or we're going to say, make sex offender laws, and the Attorney General then gets to do that. No, that is Congress's specifically ascribed duty. Through the Constitution, after all, the people have vested their power to prescribe rules limiting their liberties to Congress alone. No one, not even Congress, have the right to alter that arrangement. As Chief Justice Marshall explained, Congress may not delegate powers which are strictly and exclusively legislative. Boom. Or as John Locke, to take it back a step, one of the thinkers who most influenced the framers' understanding of the separation of powers, described it, quote, "The legislative cannot transfer the power of making laws to any other hands. For it being but a delegated power from the people, they who have it cannot pass it over to others. The people alone can appoint the form of the Commonwealth, which is by its constitution the legislative, and appointing in those whose hands that shall be. And when the people have said, we will submit to the rules and be governed by the laws made by such men and such forms, nobody else can say, other men shall make the laws for them. Nor can they, people, be bound by any laws, but those that such as are enacted by those whom they have chosen and authorized to make the laws for them." So this makes sense, though, because the legislature is the most directly elected by the people. And the legislature has the job of passing laws. They are the most closely tied to the people. The House, specifically, with 2-year terms, being directly represented by the people. The Senate, originally elected by state legislatures, but now popularly elected, whatever. Only the people can choose who gets to govern them. And the people most directly tied to the people themselves are the legislatures. The legislature cannot eschew away or throw away. It's a good question. We'll get to that in later on in the analysis. Yeah. So the people whose right it is to be governed, to choose what laws govern them, and then elect a legislature to set those laws, cannot have that right taken away by the legislature then saying, oh, this other body or this other person or this other agency gets to govern them. That would violate the very precepts of the separation of powers and of the idea of the legislature as it was construed from the beginning. Why did the framers insist on this particular arrangement? They believed the new federal government's most dangerous power was to enact laws restricting people's liberty. And excessive lawmaking was, in their words, one of the diseases to which our governments are most liable. To address that tendency, the framers went to great lengths to make lawmaking difficult. In Article 1, by far the longest part of the Constitution, the framers insisted that any proposed law must win the approval of 2 houses of Congress, elected at different times by different constituencies and for different terms of office, and either secure the president's approval or obtain enough support to overdo his veto. Some occasionally complain about Article 1's detailed and arduous processes for new legislation, but to the framers, these were bulwarks of liberty. Again, people who are going to have their actions and their liberties restricted by a law that has to be passed by Congress need to have that process be as difficult as possible, because the framers thought and believed that the excess lawmaking of a hasty legislature was the most dangerous threat to liberty. So you have to have bicameral passage. It has to pass the House and the Senate. It has to have presentment to the president. The president either has to sign off on it or veto it, and it goes back to get an overwhelming majority of the Congress. Making a law that restricts people's liberties, which all laws do that are passed through Congress, has to be a difficult process. Nor was the point only to limit the government's capacity to restrict people's freedoms. Article 1's detailed processes for new laws were also designed to promote deliberation. The oftener the measure is brought under examination, Hamilton explained, the greater the diversity in the situations of those who are to examine it. What he means is that if you have the House examine the law, the Senate examine the law, then the Supreme Court, the president examine the law, sign off on it or veto it, and then the Supreme Court examine the law for constitutionality, the better chance you have of that law actually being tenable, better that law, if there are any problems with it, will have objections raised to it. Okay. The less it must be the danger of those errors which flow, the less it must be examined, the danger of those errors which flow from want of due deliberation, or of those missteps which proceed from the contagion of some common passion or interest. Again, Hamilton and the founders were very worried about a rogue Congress, especially a House, getting all flustered up about something and passing a law which is going to restrict a whole bunch of people's freedom for no reason without some due deliberation of the Senate having to pass it too, and the Supreme Court then, after Marbury v. Madison, being able to pronounce its constitutionality or its framework. Other purposes animated the framers' design as well. Because men are not angels, Hamilton wrote that as well, and majorities can then threaten minority rights, the framers insisted on a legislature composed of different bodies, subject to different elections, as a means of ensuring that any new law would have to secure the approval of a supermajority of the people's representatives. This in turn assured minorities that their votes would often decide the fate of the proposed legislation. Indeed, some even thought the Bill of Rights would prove unnecessary in light of the Constitution's design. In their view, sound structures forcing ambition to counteract ambition. The idea that the Senate and the House would both have different ideas and different ambitions representing different constituencies. At this point in time, the Senate representing the state legislatures and the states themselves, the House representing the people directly. And so the fact that they had competing ambitions would try to stave off any kind of overwhelming rush to pass a bad law to over-restrict liberties. All right. So forcing ambition to counteract ambition would do more than any written promises to guarantee unpopular minorities from the tyranny of the majority. That's Hamilton again. I think same Federalist paper. I think it's Federalist 73. Restricting the task of legislating to one branch characterized by difficult and deliberative processes would allow design to promote fair notice and the rule of law, ensuring the people would be subject to a relatively stable and predictable set of rules. So I saw something in the chat earlier about whether or not Gundy was put on notice, whether Gundy had adequate notice. And the whole part of the purpose of the legislative process is that everybody gets notice. This is being debated in Congress. After it's passed in Congress, it has a date when it goes into effect. The decision, and we'll get into this in a second in the decision, in Gorsuch's dissent rather, the decision to allow the Attorney General to promulgate rules on the drop of a hat or issue new guidances on a daily basis defeated the whole idea of proper and fair notice for the constituency. So as opposed to being debated in Congress and don't even be put out, and if it was passed in Congress having a date of effect, the law will go into effect, the Attorney General on drop of a hat could change the entire scheme for enforcement of these rules, the entire registration requirement, and everybody who didn't do that or have notice of it would be taken into, would be held criminally liable, as Mr. Gundy was in this case. And by directing that legislating be done only by elected representatives in the public process, the Constitution sought to ensure that the lines of accountability would be clear. The sovereign people would know, without ambiguity, whom to hold accountable for the laws they would have to follow. If Congress could pass all its legislative power to the executive branch by the vesting clauses, and indeed to the entire structure of the Constitution, would make no sense. Without the involvement of representatives from across the country or the demands of bicameralism and presentment, legislation would risk becoming nothing more than the will of the current president. And if laws, for example, if the executive branch had the ability to make whatever laws it wanted, or the Attorney General had the ability to write whatever laws for enforcement, the president could direct the Attorney General at the drop of a hat to change certain laws for enforcement without any notice to the people, and then the federal agents could go start nabbing people up. So all the people on the left or moderate left or whatever, right, who have a big issue with what ICE is over, well, ICE is breaking your boundaries. Imagine how much more it could be if the president could at once revoke naturalized citizenship status, have the Attorney General change the rule the same day that all denaturalized citizens are committing a federal felony and need to be apprehended, and then deploy the federal enforcement agencies to go nab them up. Like, this is what Gorsuch is talking about could potentially happen if the scheme is upheld. I mean, it's not happening right now, but basically, if you give the executive branch power to decide how laws are enforced, when they are enforced, when they go into effect, what mechanism for enforcement, you could have a rogue executive branch literally do all those three things in one day, and all of a sudden people who don't even know there's a problem are getting picked up on the streets and thrown in the paddy wagon. And if laws could simply be declared by a single person, they would not be fewer in number, the product of widespread social consensus, likely to protect minority interests or apt to provide stability and fair notice. Accountability would suffer too. Legislators might seek to take credit for addressing a particular social problem by sending it to the executive for resolution, while at the same time blaming the executive for problems that attend whenever the measures chose to pursue. In turn, the executive might point to Congress as the source of the problem. These opportunities for finger pointing might prove tempting, temptingly advantageous for the politicians involved, but they would also threaten to disguise the responsibility for the decisions. And think about how this has already happened so often, right? That we have what's called enabling statutes, which are the Congress enables the EPA to promulgate regulations. And Chevron deference did what's made this even worse, but even still it exists. The federal government right now can, sorry, the kid was saying something in the background. The federal government can promulgate statutes that say the FBI shall do X, or the EPA is a better example. The EPA shall promulgate statutes consistent with the president's agenda to promote environmental welfare and safety. And okay, well, then the EPA can then go ahead and say, here are our regulations. They're not passed by Congress. The enabling statute gives the EPA the power to make its regulations. And some of those might be Green New Deal stuff, decarbonization, shutting down of coal-fired plants. And so the point is that even in the existing framework, even if you have non-delegation doctrine, right, what happens is that these government agencies under the enabling statute disguise have the ability to promulgate regulations that aren't laws but have the force of law. And so the EPA could go to a coal-fired power plant or go to a farming community or go to, for example, under the Biden administration, went to the Amish community who has raw milk and started taking their raw milk and smashing bottles because it was the FDA under Biden promulgated a rule that said that you can't have non-processed, non-FDA approved milk. The Amish never got notice of that. There was never any due process for that. The regulation that the Article 1 agency promulgated was able to have the force of law and send the agents out in the field to mess with people's liberties and lives. So the whole issue, thanks guys, wheat smash, milk smash, Hulk smash. Yep, thanks Pico. But yes, so I'm saying that the way that this authority is delegated in the Gundy case makes this even worse, because it's not even a federal agency who has to give some notice and promulgate regulations. It's the attorney general saying, this day I want this, the other day I want that, right? All right. The framers warned us against permitting the consequences like these. As Madison explained, there can be no liberty where the legislative and executive powers are united in the same person or body of magistrates. If you have the same person making the laws and enforcing the laws, you are cooked. The framers knew, too, that the job of keeping the legislative power confined to the legislative branch could not be trusted to self-policing by Congress. Often enough, legislatures will face rational incentives to pass problems to the executive branch. Besides, enforcing the separation of powers isn't about protecting institutional prerogatives or governmental turf. It's about restricting the people's sovereign choice to vest the legislative power in Congress alone. It is about safeguarding a structure designed to protect their liberties, minority rights, fair notice, and the rule of law. Again, fair notice is crucial in this case, as somebody in the chat already pointed out. So when a case or controversy comes within the judicial competence, the Constitution does not permit judges to look the other way. We must call foul when the constitutional lines are crossed. Indeed, the framers afforded us independence from the political branches in large part to encourage exactly this kind of fortitude, to do our duty as faithful guardians of the Constitution. That's from Federalist 78. That's Hamilton as well. All right. 2B. Accepting then that we have an obligation to decide whether Congress has unconstitutionally divested itself of its legislative responsibilities, the question follows. What's the test? Madison acknowledged that no skill in the science of government has yet been able to discriminate and define with sufficient certainty the three great provinces, the legislative, the executive, and judiciary. Chief Justice Marshall agreed that policing the separation of powers, quote, is a subject of delicate and difficult inquiry. Still, the framers took this responsibility seriously and offered us important guiding principles. First, we know that as long as Congress makes policy decisions when regulating private conduct, it may authorize another branch to fill up the details. In Wayman v. Southard, the court upheld the statute that instructed federal courts to borrow state court procedural rules, but allowed them to make certain alterations and additions. Writing for the court, Chief Justice Marshall distinguished between these important subjects, which must be entirely regulated by the legislature itself, and those of less interest, in which governmental or general provision may be made and power given to those who are to act, to fill up the details. The court upheld the statute before it because Congress had announced the controlling general policy when it ordered federal courts to follow state procedures, and the residual authority to make alterations and additions did no more than permit courts to fill up the details. This is often called gap filling. So again, and this happens a lot of time in federal. Oh, that decision was, I think there's a site to it here. Wayman, it was Madison. It was, well, which decision, Chipping Girl? Which decision? You mean Gundy? You mean Southard? You mean Wayland? Which one do you mean? Wayman, so which one? Oh. It was 2016. It was right after Gorsuch got put on the court. So the people on the people in the controlling opinion, the majority opinion, were Breyer, Ginsburg, Sotomayor, and Kavanaugh. So it was 16, yeah. So Breyer and Sotomayor were still on the court. I mean, Breyer and Ginsburg were still on the court. Scalia had just died and gotten Gorsuch appointed. I think this is Gorsuch's, and this might be Gorsuch's first opinion, but don't count me on that. Yeah, this opinion is 16, I believe. All right. In Recolic, for example, the court upheld a statute that assigned the Commissioner of Internal Revenue the responsibility to design tax stamps for margarine packages. Huh. Oh, yeah, tax stamps for margarine packages. Yeah. Later still, and using the same logic, the court sustained other and far more consequential statutes, like a law authorizing the Secretary of Agriculture to adopt rules regulating the use and occupancy of public forests to protect them from destruction and depredations. That's what became the BLM, Bureau. That ultimately became the Bureau of Land Management after that regulation was promulgated. Through all these cases, small and large, run the same thing, that Congress must set forth standards sufficiently definite and precise to enable Congress, the courts, and the public to ascertain whether Congress's guidance had been followed. Second, once Congress prescribes a rule governing private conduct, it may make the application of that rule depend on executive fact-finding. Here, too, the power extended to the executive may prove highly consequential. Okay, so we're breaking it into three different... What are you doing, child?
Can you come and pick me up because the open house is today?
Okay. Have fun, kiddo. Say hi to the people. Say hi, people. Have fun, kiddo. Be safe. All right. So okay. So this first bit here that ended at footnote 39 right here is the first branch. There's three different tripartite issues that Gorsuch goes into about the ways that Congress can properly do this. The first one is to say, here are some. Kavanaugh was recused because he was part of the ruling on the lower court. Thanks, Scotty. He issued the decision for one of the parties of the lower court. All right, so Gorsuch is breaking this into three different buckets here. The first bucket is Congress can legitimately give authority to the legislature to make such regulations as is necessary to fulfill the duties, i.e., the IRS can make a tax stamp policy. If the IRS were to make like a policy about fishing guidance or like who can fish in what waters, that would be outside the line. So the IRS can make a policy about a tax stamp, fine. The same way is that the Secretary of Agriculture can adopt rules about public forest deforestation, use of occupancy, and depredations, right? But again, the rule under this first set of possibly constitutional restrictions is that the standards have to be sufficiently definite and precise to enable Congress, the courts, and the public to know whether or not Congress's guidance is being followed. Second, once Congress prescribes the rule governing the private conduct, it may make the application of that rule depend on executive guidance. So basically here is like, okay, and this goes a lot to like war power stuff, or like a great example of it's in recent jurisprudence is the case on protective status. The Congress passed a law that says the protective status of certain countries, right, is up to a legislative branch authority to do an inquiry and make a decision. So they're delegating that authority to the executive branch within certain boundaries and certain parameters. So, for example, the power expanded to the executive may prove highly consequential. During the Napoleonic Wars, for example, Britain and France each tried to block the United States from trading with the other. Congress responded with a statute instructing that if the president found that either Great Britain or France stopped interfering with American trade, an embargo would be imposed against either country. The cargo of Brig Aurora versus the United States, the court explained that it could see no sufficient reason why the legislature should not exercise its discretion to impose an embargo, either expressly or conditionally, as their judgment should direct. Half a century later, Congress likewise made the construction of the Brooklyn Bridge dependent upon a finding by the Secretary of War that the bridge wouldn't interfere with the navigation of the East River. The court held that Congress did not advocate any authority by simply declaring that upon a certain fact being established, the bridge should be deemed a lawful structure and employ the Secretary of War as the agent to ascertain that fact. So in the temporary protected status cases, right, Congress specifically said that the Secretary of State shall have, Secretary of DHS, rather, sorry, that the Secretary of Homeland Security shall have the ability to determine what companies should and should not have protected status. So that's fine as long as the Congress says that this person can make this determination because they're in a better fact-finding position. The same way as with the Brooklyn Bridge construction, the Secretary of War was in the better position at that point in time to determine whether or not the building of the Brooklyn Bridge would interfere with East River trade traffic. So that's the second bucket that Gorsuch says is okay. Third, Congress may assign the executive and judicial branches certain non-legislative responsibilities. While the Constitution vests all federal legislative power in Congress alone, Congress's legislative authority sometimes overlaps with the authority of the Constitution separately vested in another branch. So, for example, when a congressional statute confers wide discretion to the executive, no separation of powers problem may arise if, quote, the discretion is to be exercised over matters that are already within the scope of the executive power, i.e. enforcement power. Though the case was decided on different grounds, the foreign affairs related statute in cargo of the Brig Aurora may be an example of this kind of permissible lawmaking, given that many foreign affairs powers are constitutionally vested in the president under Article 2. Wyman itself might be explained by the same principle as applied to the judiciary. Even in the absence of any statute, courts have power under Article 3 to regulate their practice. C. Before the 1930s, federal statutes, remember what happens in the 1930s? We have the New Deal, we have our buddy, FDR coming on through. Federal, I mean, not in 30, but 30s and 40s, right? Federal statutes granting the authority to the executive were comparatively modest and usually easily upheld. But then the federal government began to grow explosively. And with the proliferation of new executive programs came new questions about the scope of congressional delegations. Twice the court responded by striking down statutes for violating the separation of powers. In ALA Schechter Poultry Corporation, VUS, the court considered a statute that transferred to the president the power to approve codes of fair competition for slaughterhouses and other industries. But Congress offered no meaningful guidance. It did not, for example, reference any pre-existing common law or fair competition that might have supplied guidance over the policy questions, as it arguably had done earlier with the Sherman Antitrust Act. And it did not announce rules contingent on executive fact-finding, nor was this assigned power one that anyone thought might adhere in the executive power. Proceeding without the need to conceive of a majority of legislatures, the president adopted a lengthy fair competition code written by a group of possibly self-serving New York poultry butchers. These are called the slaughterhouse cases. It came to be one of the foundational in my view, problematic legal issues that pushed this whole New Deal legislation through and ended up leading to Shapiro and my favorite and least favorite case, Wicker v. Filburn, including a code that was a rule that often made it a federal crime for butchers to allow customers to select which individual chickens they wish to buy. Kosher butchers, such as the Schechters, had a hard time following these rules. Yet the government apparently singled out the Schechters as a test case. Inspectors repeatedly visited them and at times apparently behaved abusively towards their customers. When the Schechters finally kicked the inspectors out, they were greeted with a criminal indictment running to dozens of counts. After a trial in which the Schechters were found guilty of selling one allegedly unfit chicken and other miscellaneous counts, this court agreed to hear the case and struck down the law as a violation of the separation of powers.
If Congress could permit the president to write a new code for fair competition all on his own, Justice Cardozo explained that anything that Congress may do within the limits of the Common Commerce Clause for the betterment of business could be done by the president by calling it a code. This is delegation running riot. So this is what we get again. This is where the Commerce Clause starts to be abused and used. And I think it's only by court packing or threats of court packing that FDR got that passed. All right. In the same year, in Panama Refining Company versus Ryan, the court struck down a statute that authorized the president to decide whether and how to prohibit the interstate transportation of hot oil petroleum product produced or drawn from storages in excess of state-set quotas. As in Schlechter Poultry, the law provided no notice to regulated parties. Again, notice is key. Just as the Schlechters received no notice that the president had promulgated a new rule. Yeah, sorry, slaughterhouse. Yeah, so there were under that. The whole Schlechter case was one in a series of cases called the slaughterhouse cases, as in the houses where animals go to be slaughtered, right? But the slaughterhouse cases were what set the ground for Wicker to come around later on. So the slaughterhouse cases were the series of cases that allowed, at least at the beginning, and to some extent power remained, allow Congress to say the president should set a code regulating this. The president gets to make his own code. So yeah, the series of cases of which Schlechter is one of them is part of what is known in like legal circles as the slaughterhouse cases, which is kind of the beginning of this build of delegation of legislative authority to other aspects of the government. Yes, sir. All right. So the law provided no notice to regulated parties what the president might wind up prohibiting, leading the court to observe that Congress had declared no policy, had established no standard, and had laid down no rule. The court explained that the statute did not call for the executive to ascertain the existence of facts which the legislation as directed, that's bucket 2 above that Gorsuch is talking about, of what might be permissible, nor did it ask the executive to fill out the details, that's the bucket 1 that Gorsuch was talking about that is permissible, within the framework of a policy which the legislator has sufficiently defined. If the statute were held valid, the court continued, it would be idle to pretend that anything would be left to the limitations upon the power of Congress to delegate its lawmaking function. After Schlechter Poultry and the Panama Refining, Congress responded by writing a second wave of New Deal legislation, more carefully crafted to avoid the problems that sank these early statutes. And since that time, the court hasn't held any other statute to violate separation of powers in the same way. That's huge. Of course, no one thinks the court's quiescence can be attributed to an unwavering new tradition of more scrupulously drawn statutes. Some lament that the real cause may have been to do with a mistaken case of death by association, because Schlechter Poultry and Panama Refining happen to be handed down during the same era as certain of the court's now discredited substantive due process decisions. But maybe the most likely explanation of all the lies in the story of the evolving intelligible principle doctrine. And the intelligible principle doctrine was what Ginsburg and Kavanaugh, well, Kavanaugh didn't vote, but what Ginsburg and Breyer and Sotomayor all used. This intelligent principle doctrine was the basis under which the majority ruled in this case. The intelligible principle doctrine. This court, and then now Gorsuch is going to rail against it. This is really important because there's a minority on the court today who want to keep using the intelligible principle doctrine as the basis to rule on cases, right? Right? Thanks, Jason. The court first used that phrase in 1928 in J.W. Hampton Jr. Company versus U.S., where it remarked that a statute laying down by legislative act an intelligent principle to which the executive official is directed to conform satisfies separation of powers. No one at that time thought this phrase meant to effect some revolution in this court's understanding of the Constitution. While the exact line between policy and details, lawmaking and fact-finding, legislative and non-legislative functions had sometimes invited reasonable debate, everyone agreed that these were relevant inquiries. And when Justice Taft wrote of an intelligible principle, it seems plain enough that he only sought to explain the operation of those traditional tests. He gave no hint of his wish to override or revise them. Tellingly, too, he wrote the phrase 7 years before Schlechter Poultry, or Panama Refining, and did nothing to alter the analysis in those cases, let alone prevent those challenges from succeeding to lopsided votes. So the phrase intelligible principles came about 7 years before the cases that struck down the separation of powers even were decided. So the court afterwards goes back and mines a phrase from a pre-existing jurisprudential opinion and imports it in to try to make what they want happen. There is a good argument as well that the statute in W.J. Hampton passed muster under the traditional test. To boost American competitiveness in the international trade, the legislation directed the president to investigate the relative cost of production for American companies and their foreign counterparts and impose tariffs or duties that would equalize those costs. It also offered guidance on how to determine the cost of production, listing several relevant factors and establishing a process for interested parties to submit evidence. The president's fact-finding responsibility may have required intricate calculations, but it could be argued that Congress had made all the relevant policy decisions, and the court's reference to an intelligible principle was just another way to describe the traditional rule Congress may leave to the executive the responsibility to find facts and fill up details. For example, as Gorsuch already cited, the idea that the Secretary of War should have the ability to conduct a fact-finding inquiry and decide if the building of the Brooklyn Bridge was going to eliminate or severely limit trade, right? Hey, executive branch, Secretary of War, who's underneath you, send him out there, see if he thinks making the Brooklyn Bridge will obstruct trade in the East River. And then we'll go with whatever he says. Still, it's undeniable that the intelligible principle remark eventually began to take on a life of its own. We sometimes chide people for treating judicial opinions as if they were statutes, divorcing a passing comment from its context, ignoring all that came before and after, and treating an isolated phrase as if it were controlling. But that seems to be exactly what happened here. For 2 decades after, no one thought to invoke the intelligible principle comment as a basis to uphold a statute that would have failed more traditional separation of powers tests. In fact, the phrase sat more or less silently entombed until late in the 1940s. Only then did lawyers begin digging it up in earnest and arguing this court that it had somehow displaced sub silentio, of course, meaning in silence, all prior teachings in this area. This mutated version of the intelligible principle remark has no basis in the original meaning of the Constitution, in history, or even in the decision from which it was plucked. Judges and scholars representing a wide and diverse range of views have condemned it as resting on a misunderstood historical foundation. They have explained, too, that it has been abused to permit delegations of legislative power that on any other conceivable account should be held unconstitutional. Indeed, where some have claimed to see intelligible principles, many less discerning readers have been able only to find gibberish. Even Justice Douglas, one of the fathers of the administrative state, came to criticize excessive congressional delegations in the period when the intelligible principle test began to take hold. Still, the scope of the problem can be overstated. At least some of the results of the court has reached underneath the banner of the abused intelligible principle doctrine may be consistent with more traditional teachings. Some delegations have, at least arguably, implicated the president's adherence in Article II authority. The court held, for example, that Congress may authorize the president to prescribe aggravating factors that permit a military court-martial to impose a death penalty on a member of the armed forces convicted of murder. A decision that may implicate, in part, the president's independent commander-in-chief authority, right? So maybe even if the Congress says, okay, president, you can go ahead and get aggravating factors into military courts for certain violations, that might be more because the president has inherent Article II authority as the commander-in-chief. Maybe not so much because of a delegation principle. All right. Hey, Chipringo, since you're a mod, if there's anybody, I've been reading the case and not so much in the chat. If there's anybody who has a really good chat or a question to throw up, I think you can throw it up for me on the screen. I can see it then better. If you're hanging, Chipringo. All right. Others of these cases may have involved laws that specified rules governing private conduct, but conditional on the application of those rules on fact-finding, a practice that is, as we've seen, long associated with executive function. Again, the second bucket, which Gorsuch is talking about, is that fact-finding bucket, which is that the president can have the Secretary of War determine whether or not building the Brooklyn Bridge is a good idea or a bad idea based upon the Secretary of War's evaluation of its impact on free trade in the East River. Similarly, the TPS, that temporary protected status for immigrants from a crisis country, that the Secretary of Defense, the Secretary of National Homeland Security has the ability to make a determination on, would be another example of Congress delegating to an executive branch authority the ability to make a determination based upon a finding of fact. Okay. More recently, too, we've sought to tame misunderstandings of the intelligible principle test. In Tomley v. United States, the court considered a provision of the Controlled Substances Act that allowed the Attorney General to add a substance to a list of prohibited drugs temporarily if he determined that doing so was necessary to avoid an imminent hazard to public safety. Notably, Congress required the Attorney General, before acting, to consider the drug's history and current pattern of abuse, the scope, duration, and significance of that abuse, and what, if any, risk to the public that it was to the public health. In approving the statute, the court stressed all these constraints on the Attorney General's discretion, and in doing so seemed to indicate that the statute supplied an intelligible principle because it assigned an essentially fact-finding responsibility to the executive. Whether or not one agrees with its characterization of the statute, in proceeding as it did, Tomley may at least have begun to point us back in the direction of the right questions to determine whether a statute provides an intelligible principle. We must ask, does the statute, I just saw that, Jason, thank you, that's hilarious. Statute assigned to the executive only the responsibility to make factual findings. Does it set forth the facts that the executive must consider and the criteria against which to measure them? And most importantly, did Congress and not the executive branch make the policy adjustments? Only then can we say that a statute contains the kind of intelligible principles the Constitution demands. While it has been some time since Congress last held that a statute improperly delegated the legislative power to another branch, thanks in no small measure to the intelligible principle misadventure, the court has hardly abandoned the business of policing improper legislative delegations. When one legal doctrine becomes unavailable to do its intended work, the hydraulic pressures of our constitutional system sometimes shift the responsibility to different doctrines. And that's exactly what's happened here. So now the intelligent principle doctrine is not doing the heavy lifting it used to. And so now the court shifts again to the way that Congress works. We still regularly rein in Congress's efforts to delegate legislative power. We just call what we're doing by different names. Consider, for example, the major questions doctrine. Under our precedents, an agency can fill in statutory gaps where statutory circumstances indicate that Congress meant to grant such powers. But we don't follow that rule when the statutory gap concerns a question of deep economic or political significance that is central to the statutory scheme. So we've rejected agency demands that we defer to their attempts to rewrite rules for billions of dollars in healthcare tax credits, to assume control over millions of small greenhouse gas sources, and to ban cigarettes. Although it's normally a canon of statutory construction, we apply the major questions doctrine. Wait, let me get my line back. Go away. We apply the major questions doctrine in service of the constitutional rule that Congress may not divest itself of its legislative power by transferring that power to an executive agency. Again, so basically the major questions doctrine, right, is basically saying that if the Supreme Court thinks that something is a big enough question or has enough of an impact, then the executive agencies can't make their own rules for it. But what that line is and how far it goes and where it works is very vague. And it kind of, as Gorsuch is pointing out here, depends upon which court it is and what they really care about. Consider, too, this court's cases addressing vagueness. A vague law, the court observed, impermissibly delegates basic policy matters to policemen, judges, or juries for the resolution on an ad hoc and subjective basis. And we have explained that our doctrine prohibiting vague laws is an outgrowth of the corollary of the separation of powers. Because you can see, obviously, right, that because if there's a vague law that the legislature passes, that now the executive gets to enforce it, right? Then the fact is vague, and the executive gets to go ahead and use its own interpretation to supplant the legislative authority. That would violate the separation of powers the same way Gorsuch is arguing, I think, well here that this does too. Okay. It is easy to see 2. How any challenges to a legislative delegation can be reframed as a vagueness complaint. A statute that does not contain sufficient, definite, and precise standards to enable courts, Congress, or the public to ascertain whether Congress's guidance has been followed at once present a delegation problem and provides an impermissibly vague guidance to affect citizens. And it seems little coincidence that our void for vagueness cases became much more common soon after the court began relaxing its approach to legislative delegations. Before 1940, the court decided only a handful of vagueness challenges to federal statutes. Since then, the phrase voids for vagueness has appeared in our cases well over 100 times. Nor have we abandoned enforcing the sides of the separation of powers triangle between the legislative, executive, and judiciary. We have not hesitated to prevent Congress from conferring the government's judicial power on entities outside of Article 3. We've forbidden the executive from encroaching on legislative functions by wielding a line item veto. We prevented Congress from delegating its collective legislative power to a single house. And we policed legislative efforts to control executive branch officials. These cases show that when the separation of powers is at stake, we don't just throw up our hands. In all these areas, we recognize that abdication is not part of the constitutional design, and abdication here would be no more appropriate. To leave this aspect of the constitutional structure alone, undefended, would serve only to accelerate the flight of power from the legislative to the executive branch, turning the latter into a vortex of authority that would constitutionally reserve the people's representatives that was constitutionally reserved for the people's representatives in order to protect their liberties. All right, let's see what we got in the chat here. Not only anybody's potting it down. All right. Oh, it's a mad crazy loophole. So again, the whole purpose of the non-delegation doctrine, before we get into part 3 here, and what Gorsuch is arguing here, right, is the fact that the legislature is most accountable to the people. The legislature is elected by the people, and only the legislature should be able to pass laws that govern and restrict the liberties of the people. That's the legislature's bucket of authority. The executive has a different bucket of authority, which is to enforce the laws the legislature passes. And the judiciary, obviously, is to go ahead and see whether or not those are coherent with our separation of powers principles, with the constitutional framework, and with the protection of individual rights under the Declaration of Independence and then the latter amendments. And so when the legislature makes a vague or a delegatory statute that says, executive, you fill this in, you do what you want, there are only certain circumstances when that can be permissible. And this is not one of them. So now that's the constitutional background, factual analysis. That's how this whole thing is developed, was promulgated through New Deal legislation, even after the cases were decided that it was a separation of powers violation in the slaughterhouse, in the first of the slaughterhouse cases, the Schlachter poultry case, and in the energy case, the shipping energy petroleum case, that were decided that violated separation of powers. The Supreme Court, in order to get FDR's legislation across in the second round of slaughterhouse cases, went back to a case that was 7 years before those first decisions and imported the intelligible question doctrine that they made up more or less out of whole cloth in order to get those across the finish line. So now let's go back to SORNA and talk about the application of this legal history to the case at hand, dealing with Mr. Gundy and the delegation of power to the Attorney General. All right. Returning to SORNA with this understanding of our charge in hand, problems quickly emerge. Start with this one. It's hard to see how SORNA leaves the Attorney General with only details to fill up. Of course, what qualifies as details can sometimes be difficult to discern. And, as we've seen, this court has upheld statutes that allow federal agencies to resolve even highly consequential details so long as Congress prescribes that rule governing private conduct. But it's hard to see how the statute before us can be described as leaving the Attorney General with only details to dispatch. As the government itself admits in Reynolds, SORNA leaves the Attorney General free to impose on 500,000 pre-act offenders all of the statute's requirements, some of them or none of them. The Attorney General may choose which pre-act offenders are subject to the act. He is free to change his mind at any point in time or over the course of different political administrations. In the end, there is not a single policy decision concerning pre-act offenders on which Congress even tried to speak, and not a single other case where we have upheld executive authority over matters like these on the ground when they constitute mere details. This much appears to have been deliberate too. Because members of Congress could not reach consensus on the treatment of pre-act offenders, it seems this was one of those situations where they found it expedient to hand off the job to the executive and direct the blame for any later problems that might emerge. Hey, World Radio, how you doing, buddy? Nor can SORNA be described as an example of conditional legislation subject to executive fact-finding. To be sure, Congress could have easily written this law in that way. It might have required that all pre-act offenders to register, then give the Attorney General the authority to make case-by-case exemptions for offenders who do not present any imminent hazard to public safety, comparable to that posed by the newly proposed post-act offenders. It could have set criteria to inform that determination too, asking the executive to investigate, say, whether an offender's risk of recidivism correlates with the time of his last offense, or whether multiple lesser offenses indicate higher or lower risk than a single greater offense. But SORNA did none of these. Instead, it gave the Attorney General unfettered discretion to decide which requirements to impose on which pre-act offenders. The Attorney General's own edicts acknowledged the considerable policymaking powers he enjoys and describing his rules governing pre-act offenders as of fundamental importance to the initial operation of SORNA and to its practical scope, since they determine the practicability of SORNA's requirements to virtually the entire existing sex offender population. These edicts tout, too, the Attorney General's discretion to apply SORNA's requirements to sex offenders with pre-SORNA convictions if he determines that, as he has, that public benefits from doing so outweigh any adverse effects. Far from deciding the factual predications to such a rule set forth by statute, the Attorney General himself acknowledges the law entitles him to make his own policy decisions. Right? Yeah, good point, Shapringo. Finally, SORNA does not involve an area of overlapping authority with the executive. Congress may assign the president broad authority regarding the conduct of foreign affairs or other matters where he enjoys his own inherent Article 2 powers, like the talking about making it possible for the military tribunals to have extra heightened or extra aggravation factors that can allow the military tribunal to seek the death penalty because he's the commander-in-chief and has inherent authority over UCMJ courts and military courts, right? That would be an inherent Article 2 power. But SORNA stands far afield from any of that. It gives the Attorney General the authority to prescribe the rules by which the duties and rights of citizens are determined, a quintessentially and fundamentally, I would add, legislative power. Our presidents confirm these conclusions. If allowing the president to draft a code of fair competition for slaughterhouses was a delegation running riot, then it's hard to see how giving the nation's chief prosecutor the power to write a criminal code rife with his own policy choices might be permissible. And if Congress may not give the president the discretion to ban or allow the interstate transportation of petroleum, then it's hard to see how Congress may give the Attorney General the discretion to apply or not apply any or all of SORNA's requirements to pre-act offenders, and then change his mind at any point in time. If the separation of powers means anything, it must mean that Congress cannot give the executive branch a blank check to write a code of conduct governing the private conduct of 500,000 people. The statute here also sounds all the alarms the founders left for us. Because Congress could not achieve the consensus necessary to resolve the hard problems associated with SORNA's application to pre-act offenders, it passed the potato to the Attorney General. And freed from the need to assemble a broad supermajority for his views, the Attorney General did not hesitate to apply the statute retroactively to a politically unpopular minority. Nor could the Attorney General afford the issue the kind of deliberative care the framers designed for a representative legislature to ensue. Perhaps that's part of the reason why the executive branch found itself rapidly adopting different positions across different administrations. So again, these SORNA regulations were changing between Attorney General to Attorney General within a single administration and between all the different Attorney Generals between different administrations. And because all these regulations and these criminal penalties reach back 20, 30 years, people who are affected by these, even though they're not a popular majority, right, were getting dragged around by their noses with the regulations they were required to abide by or face 10 years in federal prison, changed it on the daily sometimes, or at least on the monthly or the yearly. And because SORNA vested lawmaking power in one person rather than many, it should be no surprise that, rather than few and stable, it have been frequent and shifting, with fair notice sacrificed in the process. Again, that fair notice being a fundamental need or fundamental benefit of having the Congress pass the laws. Then, too, there's the question of accountability. In passing this statute, Congress was able to claim credit for comprehensively addressing the problem of the entire existing population of sex offenders. Who could object to that? Well, in fact, leaving the Attorney General to sort it all out. It would be easy enough to let this case go. After all, sex offenders are about one of the most disfavored groups in our society. But the rule that prevents Congress from giving the executive carte blanche to write laws for sex offenders is the same rule that protects everyone else. Nor is it hard. Oh, yeah. Hey, everybody say hey to the kiddo and the wifey. They walk by. Say hey. Say hey. Come back and say hey. This is the camera now. That something you did broke my camera. Everybody say hi. Yeah. All right. Nor was it hard to imagine how the power at issue in this case, the power of a prosecutor to require a group to register with the government on pain of weighty criminal penalties, could be abused in other settings. Right? Like to make somebody not register with the government, to put them in jail for 10 years for that. If that's allowed to go through, it's very easy to see how that can be abused in other settings. To allow the nation's chief law enforcement officer to write the criminal law he is charged with enforcing is to unite the legislative and executive powers in the same person. Would be to mark the end of any meaningful enforcement of our separation of powers and invite the tyranny of the majority that follows when lawmaking and law enforcement responsibilities are united in the same hands. Nor would enforcing the Constitution's demands spell the doom for what some would call the administrative state. The separation of powers does not prohibit any particular policy outcome, let alone dictate any conclusion about the proper size and scope of government. Instead, it is a procedural guarantee that requires Congress to assemble a social consensus before choosing our nation's course on policy questions like those implicated by SORNA. What is more, Congress is hardly bereft of options to accomplish all it might wish to achieve. It may always authorize executive branch officials to fill in even a large number of details, to find facts that trigger the generally applicable rules of conduct specified in the statute, or to exercise non-legislative powers. Congress can also commission agencies to other experts to study the recommended legislative language. Respecting the separation of powers forecloses no substantive outcomes. It only requires us to respect along the way one of the most vital of the procedural protections of individual liberty found in our Constitution. B. What do the government and the plurality have to say about the constitutional concerns SORNA poses? Most everyone, the plurality included, concedes that if SORNA allows the Attorney General as much authority as we have outlined, it would present a non-delegation question. So the only remaining available tactic is to try to make this case small bore by recasting the statute in a way that might satisfy any plausible separation of powers test. So yes, just a few years ago in Reynolds, the government represented to this court that SORNA granted the Attorney General nearly boundless discretion with respect to all pre-act offenders. But now, faced with a constitutional challenge, the government speaks out of the other side of its mouth and invites us to reimagine SORNA as compelling the Attorney General to register pre-act offenders to the maximum feasible extent. And, as thus reinvented, the government insists the statute supplies a clear statement of legislative policy with only the details for the Attorney General to clean up. But even this new dream of a statute wouldn't be free from doubt. A statute directing an agency to regulate private conduct to the extent feasible can have many possible meanings. It might refer to the technological feasibility, to the economic feasibility, to the administrative feasibility, or even the political feasibility. Such an evasive standard could threaten the separation of powers if it effectively allowed the agency to make the important policy choices that belong to Congress, while frustrating meaningful judicial review. And that seems exactly the case here, where the Attorney General... Sorry, let me see. All right. Is this your question? Is this the one? Okay. It seems to me, based on this decision being so close, and Loodle even saying he's open to it, there'd be more Yes. I think they're percolating up. I think there has. So that's a very good question. And I think the reason why this is becoming so important right now is, all right, so you can even see, though it's not the exact same rationale because it's not the same legal question being posed. You can like put your finger in the air and see how the court would rule on this if it comes up again. My thought is that the lower courts or the Supreme Court is looking for a particularly good case to be able to go ahead and impose non-delegation doctrine as a new interpretive method. So the whole thing about accepting a case in the Supreme Court docket, so I would expect next session we should see one promulgated, because the issue is that this session we had all the Trump immigration stuff and all the TPS stuff and everything else, right? So there wasn't a lot of room on the docket to deal with a weighty case such as this. However, in the fisheries case that struck down Chevron deference, you see a lot of these same legal principles being asserted, and Gorsuch's concurrence in that really worked to supplement Kavanaugh's majority opinion in going through, or kind of concurrence in going through the same separation of powers principles. So my understanding is that probably in the next session of the Supreme Court, where there is a majority, they'd be very happy to take this up. Alito would reconsider, and we'd probably have a 6-3, because remember, on this dissent, Justice Roberts actually joined. So Justice Roberts actually joined this, and Coney Barrett usually goes with whatever Roberts says on administrative issues. I mean, I think there's not been a single case where she's broken from Roberts if there's something dealing with separation of powers or administrative law. And so at this point in time, I think there would be a 6-3 majority if a case were to be promulgated up to the Supreme Court at this point that deals with the non-delegation doctrine. I think Gorsuch's dissent here would largely inform the majority opinion, and I think it would be decided 6-3 in favor of the majority. So that's a great question, and I think this rationale laid out. I think Gorsuch's entire the second part we just read through of the entire opinion, the last 20 pages or so, was literally laying out the groundwork for a future Supreme Court majority decision that uses non-delegation doctrine and purposefully throws in disfavor or eliminates altogether the intelligible question doctrine. That seems to me what's being set up here, right? But again, because of a lot of the overload of cases from the emergency, like the emergency docket, not shadow docket, but cases that required emergency rulings because of like the Trump and all the Trump stuff, the TPS, the lower court judges overstepping their boundaries, issuing nationwide injunctions that were more the court needed to address in this session. There wasn't a case to get a case. There was not a chance to get a case like this up on the SCOTUS docket this time around, is what I think. But that's a great question. All right. Okay. So we'll start back. And it seems exactly the case here, where the Attorney General is left free to make all the important policy decisions, and it is difficult to see what standard a court might later use to judge whether he exceeded the bounds of the authority given to him. But don't worry over that. Return to the real world. The bigger problem is that the feasibility standard is a figment of the government's very recent imagination. The only provision addressing pre-act offenders, Section 209(13)d says nothing about feasibility, and the omission can hardly be excused as some oversight. No one doubts that Congress knows exactly how to write a feasibility standard into a law when it wishes. Unsurprisingly, too, the existence of some imaginary statutory feasibility standard seemed to have escaped notice at the Department of Justice during the Attorney General's mini rulemakings. In those proceedings, as we have seen, the Attorney General has repeatedly admitted that the statute affords him the authority to balance the burdens on sex offenders with the public safety interest as however he sees fit. Unable to muster a feasibility standard from the only statutory division addressing pre-act offenders, the plurality invites us to hunt in other and more unlikely corners. It points first to SORNA's Declaration of Purpose, which announces that Congress, in order to protect the public from sex offenders and offenders against children, establishes a comprehensive national system for the registration of those offenders. But nowhere is feasibility mentioned here either. In fact, this provision doesn't purport to guide the Attorney General's discretion at all. Instead, it simply declares what Congress believed the rest of the statutes and active provisions had already established, without the need for any action by the Attorney General. And by now, surely we must all agree that broad and sweeping statements like those about a statute's basic purpose are inadequate to overcome the words of its text regarding the specific issue under consideration. While those adopting SORNA might have declared that they hoped and wished for a comprehensive national system, the fact remains the new law they actually adopted for pre-act offenders leaves everything to the Attorney General. Hopes and dreams are not laws. Besides, even if we were to pretend that Section 20901 amounted to a directive telling the Attorney General to act to establish a comprehensive national system for pre-act offenders, the plurality reads too much into the word comprehensive. Comprehensive coverage does not mean coverage to the maximum extent feasible. Think about comprehensive coverage on your automobile, for example. Comprehensive means having the attribute of comprising or including much of a large content or scope, inclusive of, embracing, or containing much in small compass, compendious. So, for example, a criminal justice system may be called comprehensive, even though many crimes go unpursued. And SORNA itself contains all sorts of comprehensive or coverage exceptions for the post-act offenders, yet claims to comprehensively address them. In the same way, no reason exists why SORNA might not also claim to address pre-act offenders comprehensively, even though the Attorney General is free to exercise his discretion to forego registration of some, many, or maybe even all of them. The statute still comprehensively addresses these persons by indicating they must abide by whatever rules an Attorney General may choose. In all these ways, SORNA might be said to address sex offenders past, present, and future in a way that comprises or includes much, and that is of large context or scope, but in a way which nevertheless delegates the important policy decisions to the executive branch. Finding it impossible to conscript the statute's declaration of purpose into doing the work it needs to do, the government and the plurality next asked us to turn to SORNA's definition of sex offender. They emphasize that SORNA defines a sex offender as an individual who was convicted of a sex offense, and they note pre-act offenders meet this definition. Because pre-act offenders fall within the definition of sex offender, the government and the plurality continue. It follows that the Attorney General must ensure all of them are registered and subject to SORNA's demands. That much, however, does not follow. To say that pre-act sex offenders fall within the definition of sex offenders is merely a truism. Yes, of course, those people have already been convicted of sex offenses under state law. But whether these individuals are also subject to federal registration requirements is a different question entirely. And as we have seen, the only part of the statute that speaks to pre-act sex offenders, Section 209, 13D, makes plain that they are not automatically subject to all the Act's terms, but are left to their fate at the hands of the Attorney General. Look at it this way. If the statute's definitional section were really enough to command the registration of all sex offenders, the Act would have needed no the Act would have no need. The Act would have had no need to proceed to explain, as it does at great length, when the post-act offenders must register and when they need not. If that argument wouldn't work, the plurality points us to 209 13D's second clause, which grants the Attorney General authority to prescribe rules for registration of sex offenders who are unable to comply with the Act's initial registration requirements. According to the plurality, this language suggests that Congress expected the Attorney General to register pre-act offenders to the maximum extent feasible. Or, of course, this clause 2 says nothing of the sort. And the authority provided under 209 13D's first clause, which gives the Attorney General the blanket authority to specify the applicability of requirements of all of the subchapter, is additional to the authority granted under the second clause. So not only does the Attorney General have the authority to prescribe rules for the registration of pre-act offenders under the second clause, he's also free to specify which statutory requirements he does and does not wish to apply under the first clause. Far from suggesting a maximalist approach, then, the second clause, read in light of the first clause, only serves to underscore the breadth of the Attorney General's discretion. With so little in statutory text to work with, the government and the plurality cannot resist highlighting certain statements from the Act's legislative history, which again, thank God, legislative history is falling into disfavor. Basically, some person in some Senate debate or some House debate or floor debate said this thing about what they wanted the Act to do. Even if that certain part of the Act never passed muster or made it into the actual bill, well, Senator so-and-so said they wanted the Act to do this. So we can count that as more or less what we interpret it to mean, which is insane. As Gorsuch points out, Legislative history is not the law. Still left can committee reports or statements by individual legislators be considered to muddy clear statutory language like that before us. And even taken on their own terms, these statements do more than confirm that some members of the Congress hoped and wished that the Attorney General would exercise his discretion to register at least some pre-act offenders. None of these statements mentions a feasibility standard, and none could obscure the absence of such a standard from the law itself. This leaves the plurality and the government to try to fish for its feasibility standard from our decision in Reynolds. But Reynolds would make a difference only if it bound us as a matter of stare decisis to adopt an interpretation inconsistent with the statute's terms. So again, there's nothing that binds a court to adopt a definition from previous case if it would violate existing judicial principles. And of course, it does no such thing. The government and the plurality submit that Reynolds was premised on an understanding that Congress intended the statute to apply to pre-act offenders to the maximum extent feasible. To support their reading, they point to Reynolds' surmise that Congress may well have thought that there could be practical problems with applying SORNA to pre-act offenders, and for that reason left the regulation or registration obligations to be sorted out by the Attorney General. But speculation about some of Congress's motives in adopting Section 209(13)(d) aside, Reynolds plainly understood the statute itself as investing the Attorney General with sole power to decide whether and when to apply SORNA's requirements to pre-act offenders. Nothing found here can come as a surprise. In Reynolds, the government told this court that SORNA supplies no standards regulating the Attorney General's treatment of pre-act offenders. This court agreed, and everyone proceeded with eyes open about the potential constitutional consequences. In fact, the dissent expressly warned that adopting such a broad construction of the statute would yield the separation of powers challenge we would face today. Now, when the statute faces the chopping block, the government asks us to ignore its earlier arguments and reimagine, or really rewrite, the statute in a new, narrower way to avoid its long-predicted fate. No wonder some of us are not inclined to play along. The only real surprise is that the court fails to make good on the consequences the government invited, resolving nothing and deferring everything. In a future case with a full panel, I remain hopeful that the court may yet recognize that, while Congress can enlist considerable assistance from the executive branch in filling up details and finding facts, it may never hand off to the nation's chief prosecutor the power to write his own criminal code. That is delegation running riot. And that is the end of Gorsuch's dissent. Hey, everybody, how we doing? Well, we made it through all 32 pages of the dissent. Any questions, any comments, any concerns, any complaints? Other than I know my red underlining skills suck compared to, I don't have that special duty thing that Gavia and Sean, criminal law, potentially criminal, and that Ryan McMullally have. I don't have all that shit. I'm just like, I'm kind of like Bush League in my red underlining. So for the people who are really wanted to go over this, was my reading of the language as well as my like clarificatory comments and helping to suss out the law, was that helpful for everybody? Does anybody have any outstanding questions that you felt I didn't quite get to? Oh, hell yeah, I agree with Gorsuch 100%. Absolutely, I agree with Gorsuch. Yeah, redlining was outline. Not this redlining. That's a different kind of redlining. You're funny. Here, let me draw, in case anybody wants to come up and talk about the case or anything, I'll invite people to the studio. If anyone wants to come up and chat for a bit about the case or whatever. I mean, feel free to drop in the chat too. But if anyone wants to come up, feel free. And you don't have to have your video on. I don't really care about that. You can go ahead and just pop in via voice if you prefer. But so I agree with Gorsuch's decision. I agree, especially with the idea of separation of powers in the non-delegation doctrine. Like the legislator has for too long, both through doing Article I courts, Cool. Thank you. That was my goal. I appreciate that. I don't know what that means, but okay. But the whole point is that the idea that and this is why I also really agree with like defeating Chevron deference and the idea of trying to dial back the administrative state. The whole notion that the legislature can write a like Good Do Things Act or hey, EPA, please stop carbon pollution, and the EPA can do whatever the hell it wants to do through promulgating rules and regulations is a microcosm of the same thing. This is more discreet and more problematic because it's actually letting the people who enforce the law, the executive branch, go ahead and also write the law. And that's, again, the fundamental problem of conflation of powers that would lead to a tyranny of the majority that in all of Gorsuch's initial analysis here that Hamilton was on about. Now my margins all screwed up now. That Hamilton was all on about in the first bit of the dissent here. I don't know if I can even bother to go back, but all the notes. And I would one of the things we're going to be doing on the Natural Law Book Club coming up in the future, I think, unless somebody else persuades me otherwise, is we're gonna do notes from the underground next after we finish Marcus Aurelius on this Sunday. Aurelius's Meditations, but I think it'd be beneficial to read some Federalist papers at some point in time in the book club. Maybe not next, but at some point to go through the whole thing. Oh, Rustin's here. Oh my God. Sorry, I didn't see you, buddy. Let me pull you up. Hey, how you doing?
Hey man, is my audio okay?
Yeah, you're good.
Okay, I'm in the car, so I want.
Yeah. I was gonna say you might have a cement mixer going on behind you, but I can still hear you.
I think we like desperately need to bring the non-delegation doctrine back to be able to make.
Go ahead. No, I absolutely agree. I think that is and rolling back Chevron deference and maybe even rolling back Chevron even more and get more out of the hands of administrative agencies and more back to Congress is probably one of the best moves we can make for the country. I 100% agree.
Yeah, I think for like far too long, Congress has been able to just like kind of gesture at what they want and make the executive fill in the blanks.
Absolutely. Yeah, well, exactly. And the thing that happened, and there's a strategic reason for it, is that Congress has to go back and be elected. And they're like, oh, we passed a law that restricts immigration, but the executive fucked it up. Oh, we passed a law that restricted sex offenders, but the executive screwed it up. So Congress has been going back to the constituents for, the better part of 4 decades, even longer than that. I mean, like, oh, we passed a law that fixes that. We passed the Fix All Crimes Act. It's the administration's fault that's not getting fixed, not ours.
That's exactly right. And it also like just is a gross concentration of power in the executive that the executive shouldn't have, in my opinion. Like,
no, absolutely, it is.
Yeah, if you look at some of the like tariff laws that are under the books right now, or some of the AUMF, like these are just like broad, sweeping delegations to the president.
There are, and where the only thing I would say is like under like AUMF stuff, right? That's funny. The only difference we might have under that is that as far as AUMF goes, right, is that I think even Gorsuch would give the president more leeway because as the commander in chief, he has more broad discretion to exercise executive authority in that regard. So, like, I agree it's been overused and should be dialed back. But I think even Gorsuch would agree under this opinion or a future one that the president's going to have some level of plenary power with military action.
Yeah, this is a topic that I've disagreed with Ryan on a few times. I think that it actually we're overestimating how much power the founding fathers actually meant to vest in the executive. Like more powers.
And that's fine. I'm just saying that based upon like the precedent we have right now, right? I'm not sure what canon of judicial interpretation can screw that pig right now.
Yeah, you might be right, but like the thing is I think that even I think it was Jefferson when he was president, acknowledged that he didn't have the power to do a full-on attack on I think it was the Barbary
The Barbary Pirates, yeah. There was the Tripoli was that's where the Marine Corps was founded. Actually, that's why the Marine Corps officers carry a Mameluke sword, because we got it from the chief of the Barbary Pirates when we caught his ass. Yeah.
Yeah, even in his letter to Congress, he acknowledges like that he does not have the power to do a full-on attack without Congress's approval, and that's why he like wrote to them and why he sent the boats out.
And that's why he used the existing piracy laws to justify the military incursion.
Yeah, exactly. And so yeah, I think that especially Ryan overestimates like how much power, like war powers, the executive should have.
Sure. And I don't think, I mean, from my point of view at least, right? Like I don't think I have an overestimation or underestimation of what they should have. I just think that I'm kind of trying to analyze the terrain of the battlefield as it is and see that under the existing jurisprudence right now, even Gorsuch's and Kavanaugh, who are trying to dial back administrative state and go harder for separation of powers, I don't think there's I don't think there's a judicial principle of interpretation that right now at least can get you where you think we should go. And I'm not saying we shouldn't go there. I'm just saying that I don't see a feasible route forward to do that, which is kind of a push out on my part, I guess. But I'm just saying, like, I mean, maybe you and I could put our heads together and come up with some new judicial theory to try to work that out. But I'm saying under the existing canons of construction and judicial theories and jurisprudence, I don't see a way forward to really restrict that unless Congress wants to act and actually do something for once, in which case it could be restricted. But Congress has shown no inclination to be willing to do that whatsoever.
Yeah, I see what you're saying. And it might be the case that we don't get like the full-on separation of powers that I want. But I think
Sure.
even even just getting, it around the administrative state or around the I don't know how far they'd be willing to go with tariffs. I think they'd be willing to go pretty far with tariffs, though.
I think tariffs is kind of a hot mess. Like, define what you mean by how far they're willing to go with tariffs. Like, what exactly do you mean? So I'm not misconstruing you.
It sounded like in their previous decision, they were pretty open to like this idea that the power of the purse and taxation is just in Congress's hands. And
Right.
the executive should only be allowed to under very specific circumstances where it's clearly laid out where like
Right.
he's allowed to tax.
So you're not wrong, but I think that and the thing about the tariff case was very interesting and also problematic. It was only the tariffs under that specific statute that Trump employed to employ the tariffs, right, was struck down. There are at least a half dozen other statutes that give the president power to tariff, and I think he's trying to proceed along those lines. And those might also be struck down. And at that point, if there's a second tariff case that comes up when Trump goes a different route to tariff, right? I think at that point in time, we might get a firmer decision about where the line draws on tariffs as a whole. So right now, that avenue to tariffs has been shut off, but I think it's very possible that Trump's going to try to go around it using another, at this point in time, constitutionally vague method of tariffing, and we might get a firmer decision that actually decides that issue once and for all.
Yeah, it's interesting that they chose to rule on that specific law because I don't even think that that's the broadest like language in all of tariff.
Well, it's not. But the thing about it is, under the cases and controversy requirement of Article 3, right? The court can only rule on the case that's before it. Like the court can't extend it out to do other tariff laws. Like the court can only actually address like the same thing as like, for example, in this case, the relevant part of SORNA that was being talked about was section 209.13, right? A through F. And so the decision the court issued here could only actually touch on that which was brought up from the lower courts. Like the court, if the court were to give an opinion on sex offender registry writ large across all scopes that weren't in the case before them, that would be called what's an advisory opinion. And there's a lot of case precedent that says that the court can't issue advisory opinions, or if they do by accident, it has no binding authority. So the same way in the tariff cases then, right, the only thing that was before the court was that one specific statute Trump used to leverage to make his tariffs. So as much as the court might have wanted to, it would be beyond the court's power to actually do a broad sweeping ruling on tariffs in general, even though it might have wanted to.
Yeah, no, I understand that, but
Okay.
I fail to believe. I guess I just don't believe that there hasn't been like a challenge under some of the other laws that he's imposed tariffs.
Oh, there have. It just hasn't gone up yet.
Yeah, that might be the case, but
Yeah.
yeah.
Go ahead. Sorry.
I was just gonna say I do think that there's more, like significantly more broad language laws around tariffs that give the president like basic like broad discretion on when and how much to tariff countries.
No, absolutely. And the thing about I think about that too. The same thing is with like sex offender laws here, or even authorization of use of military force laws, or war powers, or even the ability to do drone strikes or occupations on small scales for limited times, or invasions like what happened in Venezuela, right? Congress has the power to act and restrict those by giving clear guidelines. And Congress, and again, it goes back to what we were talking about before, that no congressman wants to put his foot in his mouth and say something that's unpopular. It's better just to have them, MSNBC and Fox News fight it out on their airwaves and not actually have to put your actual skin in the game on issuing an opinion, which is terrible.
That's exactly right. Yeah, they don't want to take responsibility. They want to just blame the president for everything. I mean, look at the Republican Party and what they ran on in 2020, right? Or 2024. Like, Biden sucks. Like, we have to get Biden out. We can't let the Democrats continue because the Biden did so bad. And then in 2020, the Democrats won off of Trump bad. And like, this is what I think.
And this midterms, everybody's going to run off of Trump bad again and war bad. And Trump's a liar because he said no wars and now there's wars. And so the whole thing is like the legislator has sat there with their thumbs up their butts for the last 20 years, not doing a damn thing about anything.
Yes, that's exactly correct. But I think the reason they've been able to do that is because we have allowed them to delegate powers so broadly.
Right. No, I agree. I think you're right. Like doing away with the non-delegate or enforcing the non-delegation doctrine, doing away with the delegation to administrative agencies via Chevron, and also via administrative acts that give specific power to the executive, like the SORNA case here in Gundy, right? If we get rid of that, the legislature is going to actually have to do something. And the thing too is that the legislature benefits because, okay, you have this situation where the president's the one out there making campaign promises. He's going to do X, Y, and Z, right? And so he gets into office. The legislature won't do, whether it's Biden or Trump, Obama, I don't care, any president in the last 40 years, gets into office with campaign promises. The Congress won't act on anything and says, oh, you do it, president. Oh, you do it, administrative agency. And the president's like, okay, well, I have to at least look like I'm trying to do what I promised I was going to do. And so starts doing a bunch of random shit that becomes unconstitutional. And the Congress gets to sit back and not take any of the flack from it. And that's a huge problem.
Yes. Yeah. And the thing is that I think Gorsuch touches on this, if I remember correctly, that it also creates like this world where the interpretations can change the laws. The interpretations of the executive can change the laws. So like what is a law under Obama might change and not be a law under Trump. Like,
well, we saw this. This is the perfect example of the SORNA case. Is you had different attorney generals within the same administration completely rewriting the laws for sex offender registries, and then between administrations completely flipping that back and then back again. So yeah, this is the perfect case example of that.
Yeah, I believe this happened with like ATF things as well, right?
It did. Yep. With whether or not the ATF can itself designate a class of firearms or firearm components as enforceable. Yep.
Yeah, exactly. Yeah, that is the one I'm thinking of. And then there was also the ghost gun ruling. I don't remember if that one played into this.
Yeah, the ghost gun ruling was part of whether or not the ATF can, and that was again. It bugs me, but it's a good thing that the Supreme Court can't make sweeping decisions. That was dealing with whether or not the ATF's designation of a receiver as 0% completed, 60% completed, or 80% completed was within its discretion. Like, could the ATF label a block of metal so a 0% complete receiver as a firearm?
Yeah. Yeah, I'm remembering now.
Yeah. So that was like, again, it was very narrowly tailored to that, but it also it puts the ATF on notice that they're going to do a bunch of crazy shit. The Supreme Court right now might smack them down again. So there is a deterrent effect, but again, when the administration shifts, all bets are off. So Chapingo asked a question here. I'm not sure if you can see the screen, but Chapingo said something, or he made a statement, I suppose. That's mostly what he does. If we can keep the power separated, the Congress will be discouraged from passing things, as then the buck will stop with them. I think it's the opposite. I think if we keep the power separated, Congress will be encouraged to actually pass stuff that actually is a law. So maybe that's what you meant, and I'm misreading it. Like if we keep the power separated, Congress will have to pass stuff because they can't pass the buck from now on to the administrative agencies and to the executive.
What I think he's getting at is that they're going to be less likely to pass laws because they're going to be now the ones that hold the responsibility for how those laws play out, because they can't blame the president anymore. It's how their laws.
Okay, but then I guess the alternate thing is, like, is it better to pass a law that's not a law and not bound by our principles of the Constitution and says, Attorney General, make your own laws? Yeah, very, very unpopular. It says less likely to pass poor laws. And the thing too is, like, okay, so you have a congressional representative who says, I'm going to combat sex offenders. That's my campaign promise to you, right? So they go through and they promulgate this law, SORNA, and they say, Attorney General, you make the law, right? Like at that point, but then that congressman goes back to his constituents and says, I passed SORNA. I've solved the sex offender problem. Look at me. Like he wouldn't have that same cover if those kind of laws had to actually, like, it would maybe make the law-making process more slow. Also, it might encourage people to adopt the premise of one actual law per bill, like one thing per bill, no omnibus, no nothing. Okay, Chapingo agrees. It'd be less likely to pass shitty laws. Okay, cool. Yeah. And that may mean less laws get passed, but I would rather have less laws in general, and I think our framers agree with this. I'd rather have less laws if that means less shitty laws, like only have good laws be passed and no shitty ones, and no not laws that the Attorney General gets to enforce.
Yeah, I think pretty much everyone agrees with that. Like, I think if you disagree with that, you're just, I don't know, like
you're a statist.
Yeah, that's right.
Yeah. All right, cool. Hey, well, Grid's in here. You want to do a three-way, or you want to pop? Oh, what else you got to say, buddy? I mean, you can welcome to stay on. Hey, why don't you stay on?
Yeah, okay. I'm gonna mute. My service is about to get bad anyway, so
okay, cool.
I'll
stay on. Come back when you got good service.
Okay, sounds good.
All right, cool. Hey, Grid, how you doing, brother?
What's up, man? How are you?
I'm well, man. I switched up from debate reviews to doing a bit of law review today.
There you go. Are you going over the recent decision?
It's an older decision. It's the Gundy decision, but it's where the Gorsuch articulates his non-delegation doctrine. Basically, that the idea that the legislature should stop passing the buck to executive agencies. In this case specifically, it was with the Sex Offender Registry Act. It gave the Attorney General the power to make all the laws and all the regulations that they were then going to enforce. And then through a series of Attorney Generals, some within the same administration, they changed the laws on a daily basis. There was no notice given to sex offenders about how they had to register or not register. And that changed back and forth 6 times without Congress doing anything. The Attorney General only passed the law. And our guy Gundy here got caught up in one of those no notice situations where one day he was good, the next day he's going to prison for 10 years. And Gorsuch points out that it's very sad that this case had to come up through a very unpopular part of the population, sex offenders. But we have to keep our ducks in a row here that even the most disfavored among us deserve the same constitutional protections. And we can imagine in a very similar world how if Congress were to pass a law that says that the federal government, that the executive branch, the Attorney General gets to decide all immigration enforcement action, what constitutes immigration law, what constitutes a violation, then the next day, Trump could say, anybody who's here on a green card is no longer a legal immigrant. And the Attorney General the same day could then send ICE out to go get all the people who've been here for years as documented legal citizens, because that would delegate the same authority to the executive branch to make the law it's then going to enforce. So that's kind of what, and so Gorsuch in his dissent here is saying we need to revisit this and say that the Congress needs to do better about saying, here is the actual law, here's how it's enforced. Stop delegating it to Article 1 agencies, to the EPA, to the alcohol, tobacco, and firearms, make the actual laws that are to be enforced by the executive. Don't give the executive agencies the ability to make the laws they're also enforcing.
Yeah. So, I mean, it's technically legal.
I mean, it is right now. Yeah, we haven't revisited this yet.
So
this was Gorsuch's dissent. Yeah, but what I'm thinking, I'm hoping at least, is that in the coming session of the Supreme Court, there'll be, because so the dissent here was Thomas, Roberts, and Gorsuch. Alito, and the majority here was Breyer, Kavanaugh, and Breyer, Sotomayor, and Ginsburg. So this is his 2016 decision. But the point being is that in the new session of Congress, or of the Supreme Court, I think a new case will come up where Gorsuch's dissent here will become the majority opinion, because it seems very much in line with what the court was doing by striking down Chevron in the fishing cases.
right. So, I mean, it all seems like, and I haven't read the opinion, and I wasn't listening to you read it.
That's fine. You can go back and listen to it. I have a sultry voice.
Thank you. But at the end of the day, I think that one of my big problems with the Supreme Court, or pardon me, with Congress actually, is that they've been basically delegating. That's really not the right word.
No, that is the right word. That is the right word, actually.
But they've been basically, rather than Congress make decisions, they've basically been pushing it to the Supreme Court, which is exactly backwards of the way it was supposed to be, and it's an election security thing for Congress.
Sure.
So your congressman can always say, "Hey, we voted for this, but the Supreme Court found it unconstitutional. I did the best I could. I'll vote for it next time." Or that just as easily say, "Well, that got pushed to the Supreme Court to make a decision, and they made the decision, not us. So I would have voted on it, but I never got the chance to."
Right. So there's one missing step there, and that's Congress pushes it to the agencies to do what they're going to do, and the Supreme Court rules on what the agencies or the administrative or the executive branch does.
Right.
So, but you're not wrong.
But they're not doing that either, and really they ought not be doing that, right? Like,
right.
This is the backwards part of the way the agency system that we've adopted is working.
Mm-hmm.
Congress should make the law.
Nope.
The Supreme Court should interpret the law, and then and only then should the agencies have anything to do with the law.
Yes.
What we have right now is we have the agencies being involved beforehand, advising Congress on what they want to do or can do in a lot of cases. Then the agencies are also participating in the Supreme Court hearings, giving opinion before the law is even interpreted, which is also wrong and ought not happen.
Yes.
And then they're involved the third time when the law is actually finally interpreted, handed down. The agency themselves have latitude to whether or not they're going to enforce it at all. So
yeah, but that's a Chevron deal. Yep.
Yeah. And so when the problem really starts with Congress and how they've allowed these agencies that work for them to dictate more or less what's going to happen.
Yep.
And
can I read you something real quick from the decision?
Yeah,
that
absolutely.
Goes to this exactly. Okay. So this is from Part 2A of Gorsuch's dissent. It says, "Our founding document begins by declaring that we the people ordain and establish this Constitution. At that time, that was a radical claim, an assertion that sovereignty belongs not to a person or institution or class, but to the whole of the people. From that premise, the Constitution proceeds to vest the authority to exercise different aspects of the people's sovereign power in different distinct entities. In Article 1, the Constitution entrusted all of the federal government's legislative power to Congress. Article 2, obviously the executive, and then the president. The framers, each of these vested powers had a distinct content. When it came to legislative power, the framers understood to mean the power to adopt generally applicable rules to govern future actions by private persons. That power shall prescribe the rules by which duties and rights of every citizen are to be regulated. That's from Article 1. Or the power to prescribe general rules that govern the conduct of society. The framers understood, too, it would frustrate the system of government ordained by the Constitution if Congress could merely announce vague aspirations and then assign others the responsibility of adopting the legislation to realize those goals.
Yeah. Well, I mean, and that's exactly what I see happening.
No, absolutely.
And it's a very interesting position that we find ourselves in here legally, because at the end of the day, no one is claiming actual responsibility. Nobody's putting the foot down. And it's really, and what should scare everyone is it's your local courts, your smaller courts that are actually deciding these things. And that should really scare you.
Yeah.
Because a court in Nowheresville, California, making a decision that affects the entire United States.
So let's clarify that real quick, right? So you mean the lower level district federal courts, like a state court? Yeah. That can issue a nationwide injunction based upon what some judge, blue-haired, whatever says, right?
Yes. In Nowheresville, California, one judge can say, I wanted this injunction. It goes to the circuit court. The circuit court says, well, I don't see any reason why not to do that.
Right.
And then it stands.
Yeah, it stands.
And this is insane.
Yeah.
This is not it. That's the wrong way this is supposed to flow. It's not supposed to flow from your small court upstream to the larger court. Right? This is why people ought to serve in the military. While a guy on the ground can give information, he doesn't have the whole picture. So he gives information to his senior officer. That senior officer goes to his senior officer and says, hey, I've got this information, and here's my opinion about this information. That senior officer goes to his senior officer and says, hey, I've got this guy's observed this. Here's the comments from his superior officer. I've looked at it. This is what I think. What do we do? Now that superior officer says, well, this is what we're going to do. And here's why. Or he may not even say here's why. He just say, this is what we're going to do.
Right.
And then it goes back down. So we don't, at no point does the guy that starts the chain say, this is the way it's going to be. And I'm not taking another step.
Right. Well, not only that, but it's even worse than that, right?
I understand. I'm trying to simplify it down, but
let me use your analogy to make it actually contextual. It's like, okay, I ran it up my chain of command, and they told me to go fuck myself. So now I can go to the Air Force chain of command where there's a guy who's really more sympathetic, and I can go to the Air Force major and run it up his chain of command instead. Yeah, we'll still have the same force of me. Yeah. Yes,
and if I don't like what my chain of command says, I just say fuck it and don't do it anyway.
Right, because the Air Force guy told me it's okay for me not to.
Right, yeah, and it's insane. It's literally not how any of this is supposed to work. Your smaller courts can decide things in their area, but they really have a definite sphere of influence, just like the E5 that's painting a fucking wall. Yep. Doesn't get to decide what color that wall is, and he doesn't get to decide that, well, I don't like painting this wall. I want to paint that fucking wall over there.
Right. Right. No, absolutely. And that's one good thing that came from the Supreme Court's recent session is there was a program put out on nationwide injunctions by district courts accepting class actions, which is a huge step. They've still been doing it, and they're going to get smacked down. But that's the first step in actually fixing the problem, is that saying that unless there's a class action that affects a nationwide class, you idiot blue-haired judge in California cannot bind the entire nation. That was huge, but they've been running around on it. Yeah.
But just to continue with the military analogy, so you've got a bunch of E5s running around there thinking they run the show. You know, right? They got the E5 mafia. They're fucking. They think they run shit.
Yeah.
And you got a bunch of and their sergeants are tired of their shit. And then it goes up, and you got a couple of lieutenants don't know what the fuck they're doing. And now you got a captain running around out there, right? This is your district court.
Sure.
right?
Or I
And
guess your
district
circuit court, I suppose.
Yeah, circuit court. Your ninth circuit court, fifth circuit court's like, yeah, I don't know what to do with these guys. Just fuck. I'm just gonna leave it. I'm just gonna leave it to them. Like fuck it,
Sure.
whatever. I don't care.
Pass
And
the law,
then
yeah.
and then then the Supreme Court says, hey, no, you can't do that. You got to do it this way. But rather than actually go down and say, hey, bunch of E5s, don't stop that shit. They goes right back down and gets stalled
by the E5s
because nobody wants to do it. The lieutenants don't know what the fuck to do. The sergeants are sick of their shit and don't care anymore. They've gone, they're hiding somewhere. They don't want to have to do, right? And so what you got is you got this lower court that just feels like they can do whatever they want.
Yeah.
And then the captain gets tired of it, and he's like, you know what? I really don't give a shit what everybody else above me said. I'm just going to let it stand. I'm not fixing shit. I don't even care anymore.
Right.
As a matter of fact, I'm going to draft a letter. I'm going to draft a letter to the JAG saying that fuck you. These walls are all going to be pink now, and we're painting every other wall. And I'm a captain, and I can do that.
Right.
Right? Like, this is the insanity that we're realistically looking at. I'm trying to do a military analogy here so a lot of people can understand that
by the time
these
it
are
makes
very
it back up the
defined
chain, by the time it makes it back up the chain and back down the chain, if it ever does, like none of those people, the people have all ES by then.
Yeah, and they're all gone.
Yeah.
Yeah, they're all gone. They're all like, fuck it, I'm out anyway. I'm out next week. Fuck them.
Yeah, I'll put a swastika on. I don't care.
But I mean, it's just I'm trying to use that analogy because the courts have clearly defined responsibility and clearly defined limits. And yet you have judges that are ignoring their limits.
Yep.
Completely ignoring it. And it's been this way for a long time. This isn't just a reaction to Trump, although it's gotten certainly far more apparent.
Yeah.
But even back, Bush, Obama, every president, it's the courts are the lower courts seem to be out of fucking control. And here's why I believe that is. I believe that is because the Supreme Court has so much going on that they can't do anything about these rogue district courts.
Not in any kind of expedient manner, no.
Right. And so,
well, the thing too is like it's very interesting too is to my analogy of like swapping your chain of command between like the Marine Corps and the Air Force is what's called forum shopping for district courts. Is that because the district courts can enter federal nationwide injunctions, you have a very specific number of very crazy, very lefty judges, right? Mm-hmm. That are shopped to. And so you'll have these very powerful Democratic or whatever political party PACs, right? Who know they have a friend like Judge Zenas is one of them that's been on blast. Like Judge Boasberg in D.C. with the Oberga Garcia case and Turn the Plains Around case, right? You have these very specific forums, which no matter what it does, because it's nationwide, the people who have interest will run to these very specific judges who they know they'll get a favorable ruling from them because they're ideologically captured. So if I know Air Force hates work on Sundays and the Marine Corps or work on weekends at all, like the Air Force has an opprobrium against any kind of work on the weekends. And so the Marine Corps is making me work on the weekends. So I'm like, I take it in my chain of command, like, you're a fucking Marine. You're going to work on the weekends. I'm like,
right.
Let me take it to the Air Force. Hey, Air Force General, should I work on the weekends? Hell no. That's a human rights violation.
That's blasphemy.
Right.
Blasphemous.
Right. But that's what's going on with the forum shopping. So even though you're completely right in the devolution to these inferior district courts, but it's even worse than that because the people from no matter what state they're in can go file their case with the judges they know are going to be on their side and completely short circuit the system. Right.
That's accurate. And it's really bad now. I mean, it's really, really bad with the courts. And part of the reason it is that way is, again, Congress, basically since Kennedy was shot in the head, Congress has not done jack shit that they weren't forced to do.
And even when they did, they didn't do it like
they do a half-assed way. Then, like they're legit E5 mafia. Like they're not going to do anything, and when they do it, it's going to be half-assed, and it's
Right.
and this is just so you don't ask them to do it again.
Right. Well, and the whole reason for that, and you brought it up earlier, but it's something we went over earlier on the stream before you got here, was that because, for example, if I in Congress pass the No More Pedophiles Act, and then give it, so okay, Department of Justice, you figure out what the hell that means. It just says No Pedophiles Act. Underneath it says your statutes do good things. And then I can go back to my constituents in Iowa and be like, I passed the No More Pedophiles Act. Yeah, win, win, win. I ran on that. We won on that. I voted for it. It passed. And however the fuck that actually turns out has nothing to do with me anymore. So we're passing a bunch of vapid bullshit legislation and requiring either Article 1 agencies or the executive branch to make any good on it. But I can go back to my constituents and say, I passed the Save All Kitties and No Pedophiles Act.
Yeah.
And that's terrible.
It's just a really. So I think
really, Raston. Sorry, go ahead. I think Raston wants to say something. We got a third.
Okay,
Raston.
Yeah, I just wanted to expand on the analogy earlier to kind of include non-delegation doctrine in it, and it's kind of like if the E7 in this case tells the E4 go paint the walls, like, and then the E4 paints the wrong wall and then uses the wrong color. And then we're like, well, it's the E4's fault. He's a dumbass. Like, it's like, no,
actually,
maybe
it would be the E5's fault. The E5's the petty officer or the
Yeah. I think Raston, you're a corpsman, right?
Yes, I was a corpsman.
Yeah. He knows.
Yeah.
Go ahead.
So yeah, you're right. If an E7 comes over and says, "Hey, go paint that fucking wall," and the E4s go, "Okay," and they go over and paint the wall, and the E5 comes by later and goes, "What the fuck are you guys doing? You're painting the damn that's the wrong wall. That's the wrong color. What are you doing?" And then he knows that it's not going to be the E7's ass. It's going to be his ass, right? And yeah, so that's fair. Look, all I'm saying, I'm trying to draw these analogies because.
But let's make the analogy a little clearer then, okay? So let's say the E5 is okay. So let's say that the E5 is the district court, okay, the federal district court. Is that there is no mechanism in place to actually get that E5 in trouble. Like, there's no way to, they're already appointed to a lifetime appointment. The whole good behavior or during periods of good behavior clause has never been exercised. There's nothing the Congress is never going to vote to impeach any of these judges, at least at this point. So you have an E5 who's walking around supposed to be supervising the E4s, knowing the E4s are fucking up. And you're like, well, I don't care. I can't get in trouble. Like, I have fucking sovereign immunity from any of the punishments.
Yeah, I'm not part of this unit, so you can't fuck with me.
Right. Or like I have a get out of jail free card from the fucking major general.
Yeah, right. No, that's true. And but it's only this way really because Congress has gotten to the point where they will not really pass a law. And even when they do pass the law, they literally count on it being vetted in the Supreme Court and challenged, and it may never make the light of day. They get to go back. And this is because Congress's only concern is to get reelected.
Yep.
That's it. And so all they want to do is go back to their constituents and say, well, we tried.
Yep.
Or, hey, yeah, it's a big win for us, guys. We got it. Oh, no, it's not going to go through because the Supreme Court struck it down. Oh, that's terrible. Wow.
Let me read one more section again to both of you gentlemen and get your opinions on it. This is from the decision. It's quoting John Locke, as Gorsuch says, that one of the thinkers who most influenced the framers' understanding of separation of powers. He says, the legislative cannot transfer the power of making laws to any other hands, for it being but a delegated power from the people. They who have it cannot pass it off to others. The people alone can appoint the form of the Commonwealth, which is by constituting the legislative and appointing in those whose hands that shall be. And when the people have said, we will submit to the rules and be governed by laws made by such men and in such forms, nobody else can say other men shall make laws for them, nor can the people be bound up by any other laws, but such as are those enacted by those whom they have chosen and authorized to make the laws for them. Thoughts?
Yeah.
Oh, sorry. In order. Go ahead.
Yeah, so I was driving, so I didn't reply to something you said earlier, Grid, but I think it's important because, like, I think the problem you're pointing out is a real problem, and I think it's actually because Congress is able to be unspecific with these laws, and non-delegation doctrine, to me, is the solution to that. because the law will be struck down completely. They won't be able to pass the No Pedophiles Act unless they say exactly what the No Pedophiles Act is, and what it's supposed to do and how it's supposed to be carried out.
Well, and I mean, and I hate to like be so trite, but remember the Healthcare Act. It's we have to pass it so we know what's in it.
Well, sure.
This is how our Congress is operating, and that's how the courts are largely allowing them to operate. And you are right. When was the last time a congressman was called on the carpet for really anything other than getting his dick in the wrong hole? Like that, like that's like they don't even I don't even think they get arrested for DUIs anymore.
Well,
like
I think they have their "I'm a senator" card. Take me to the nearest hotel where my hooker's waiting. Right.
But
I think Rasmussen's point's a little bit more concrete than that. Is saying that if the Supreme Court were to enforce a non-delegation doctrine, being that all the laws that Congress passes have to say exactly what they're doing. There's no more passing the buck to anybody else. That might be a good first step in solving that.
It is a good first step. I think it's a solid first step. I mean, I'm, and I understand. Look, guys, I get it. It'll never happen. We have way too much lawfare in this country for it to happen. But I really do believe in the idea of that all laws passed ought to be on one sheet of paper.
Sure.
Like if you can't explain it that clearly, it should not be a law.
Or front and back, maybe, if it's very detailed.
It may be front and back. If you have to have definitions, like if you have to, like if you have to, like a concordance, right? Like we're defining X as this very specific thing.
But if nothing else, all laws passed should be limited to one single topic. No omnibus, no ACA.
No omnibus. I'm totally on board with that. I think that's a good thing. So,
you have to be careful about that as well, because like in an effort to shorten the law and exactly how, like when Congress spells it out, you might leave too many gaps there for the executive to fill in, which is
this is actually hilarious. Like what if the piece of paper is the size of the Empire State Building?
That's gonna be a large piece of paper.
That'll be the first thing. We'll have Rand. We'll have the DNC like unrolling the piece of paper in Congress. Sorry, go ahead.
So the thing about these like overly verbose bills and laws is that nobody actually understands them. Like you literally have to sit down with the law degree, go through the whole thing. Look, you're going to be constantly looking up what they mean by using this term in this aspect, and then you're still going to have 5 lawyers argue that none of what you think it means anything.
Well,
and so it's just
like the people who write the laws aren't even the congressional delegates themselves. They have a team of staffers and legal analysts who write the proposed bill and then merely brief them on it with talking points.
Right. And so they can't, they say one thing and it means something completely different because they didn't write it. And at the end of the day, I think that it's, I think it was George Carlin who said that the average American commits 7 felonies a day without knowing it.
Something like that. And then Beria, Stalin's head of secret police said, "Show me the man, I'll show you the crime."
Right. Yes. And this is because our laws are we're overcomplicating everything, especially at the federal level. The federal level, I don't believe that half of this shit is worth even talking about. Like now you could get into specific state and city ordinances because they apply to you and your community and what your lifestyle is in there. I could see that, but federal law is just ridiculous for no good reason, especially not if you're a constitutionalist that believe in states' rights over federal right.
I wish we lived in that world. But the federal government has its hands in every little corner.
And the Commerce Clause in Wicker v. Filburn, which we'll go over soon, is what kind of enabled that, right? Like if there's anything involving commerce, then the federal government can regulate the hell out of it and actually criminalize you for it, and you have no recourse.
Right. No, you're right. So I think it's interesting. So no video review today.
I might do one later on. Actually, I thought I watched Alish's debate against what was his name on the World War Alish versus. Let me find. I made a thumbnail for it, but I was like, I don't know. So
have you seen the thumbnail for my show today? For my show?
No, I haven't. I was already on, so I didn't. Garcia versus Alish. So it's the way Alish makes an incoherent argument. Garcia, for whatever reason, it'll be the Alish comedy hour. Don't worry. But Garcia, for whatever reason, thinks that like spoken word poetry makes a good opening. Like he sounds like a like Southern Baptist minister on cocaine.
That's pretty funny.
It's actually rather hilarious. So I think I was going to review it for the lulls later on. But while we're here, why don't because if everybody here's interesting debate, why don't you talk about the Nashville thing real quick?
Yeah, I threw the thumbnail for tonight's show in the back. It's pretty funny.
I got it. Let's go. Oh, hey.
Yeah, right. Clash of the Gun Bunnies. It's going on now.
I'll be there.
The Gun Bunnies are fighting each other. It's awesome.
Is it to the death or to the pain?
I don't know. It's to the pain. I think they're all pains in each other's ass.
That sounds like it.
It's just a bunch of women doing women shit. It's gonna be funny.
Hilarious. Well, I'll hop.
Yeah.
I'll at least be in the chat, or I'll hop in if you want me to.
Yeah. I'll. Matter of fact, let me remove this, and then let me see if I can. I'll see if I can share my screen really quick, and we'll give you a taste, just a taste.
It's a sample.
Yeah. So this is all right. So the thing that's going on is out in. I
like the wordplay there. The Alice the hoot. Thanks, ukulele.
Yeah, she is a hoot. So apparently this OF girl, OnlyFans girl, who does shoot, is kind of, doing social media stuff about her shooting guns and stuff. And somebody, I don't know how the competitive shooting women got involved exactly. When looking into it, we're going to talk about it tonight. I won't give too much away. But the response, the infighting, the girl fighting between the two has been legend. This is Full Metal Jessie giving her response to these girls.
Okay,
I'll play it if you want to.
Let's see it real. No, yeah, absolutely. Do I need to give you privileges, or you can just play it?
You should just be able to play it. I mean, no, you just pop it up and I'll play it. I'll hit play.
What do I pop it up at? Sorry.
You just hit. You click it.
Oh, there you go. I saw. I'm done.
Teaching them firearm safety, how to be a proficient shooter, or adding another great 2A advocate. What if instead we shame them? We drive them away, particularly women, and push them out of the community so they feel as uncomfortable as possible. Right. I love it.
Missed the part. Missed the first part. It's all right.
All right. It's all good. It sounds pretty interesting. I also like how she's pointing the muzzle right at the screen. That's always fun.
Yeah. Well,
I always feel like I'm sorry. I'm always feel like I'm a rated officer needing a duck.
Yeah. It's one of those things.
That's a joke. I mean, it's a screen.
Hold on.
It's a screen. All right.
Yeah. So I got. Oh, dang it!
Oh,
Stop it.
Well, let me tell. Okay, it's up. Let's go.
Yeah, there we go. Why didn't it?
I have no idea.
You're ruining the culture. This is America. We like guns, big titties, and desecrating the American flag to make apparel for the 4th of July. What a great idea. What if, anytime we see someone expressing any remote interest in firearms, instead of pulling them in and teaching them firearm safety, how to be a proficient shooter, or adding another great 2A advocate, what if instead we shame them? We drive them away, particularly women, and push them out of the community so they feel as uncomfortable as possible. I love it. Jarvis, write that down. Who fucking cares? They're models. You don't get mad when Nike puts a chick who's never played tennis in her life in a tennis commercial because you know it's a model. You don't really give a shit. You shouldn't. And if you do, maybe you need to take a little internal look at yourself. Why does that make you so insecure? Why are you so bothered by this? You know what you could do that's better with your time? Go dry fire. Or maybe work on pulling that stick out of your ass because all you look like is a jealous little fuck. And if you're so worried about it, maybe try being hotter. Go to the gym, get a nose job. I don't really give a shit. But this is an ugly look, and I don't like it. Stop shaming people in this community. Who cares? You see a girl that's out there in a bikini, you know what? Go fucking help her. I'm happy to see anyone out there that's promoting firearm safety, our Second Amendment rights. That's what this is about. America. And being so real, that's part of this culture. And that's what makes it so fucking sick. big tits, guns, fast cars, whiskey. It's a good time. So stop ruining it for everybody. You're a fucking hater. Now, if you'll excuse things to tend to than worrying about some gun bunny on the internet.
Okay. That's hilarious, man. So are you gonna have any of them actually on, or are you just gonna be
No. I thought about reaching out to them, but that's too much crazy in one.
All right, fair enough. I was gonna say.
So there's 3 of these girls. This is Full Metal Jessie. Obviously, she's actually pretty awesome. She used to shoot for Beretta, and she's one that's like, hey, I've done stupid shit. It's okay, whatever. and so the OF girl came in and I think her and this girl got into it. We'll get into this tonight. I don't want to give too much away.
Yeah, don't give it away. It was a nice teaser.
Yeah. And this is just, it's so funny. And there's so much to talk about these gun bunnies and the culture around the gun bunnies and how the industry uses them and everything. It's just going to be, because, I'm a competitive shooter. I was out shooting. I shot a match this weekend, and it's just hilarious. They're literally like, there's a bunch of dudes who are all dick hurt about this because, chicks with big tits take sponsorship dollars away from mediocre shooters that might otherwise get sponsored. It's gonna be a great show. You guys are gonna love it. You guys are just gonna fucking love it. It's gonna be awesome. It's gonna be. I mean, Boobgate went on way longer than I thought it would.
I mean, boobs go on forever.
Yeah, boobs go on forever.
Only humans stay the same.
Right. Yeah, and but yeah, so we got a lot of stuff going on with that. We have the Battleground. Coming up. You're doing one. I think you're probably. We've got you and Bones and you and Vince.
Yeah, we got a big build up. We're gonna have all the time. I'm excited.
Yeah, and then Vince is going against Enrique Tarrio.
Really, Vince is gonna do Enrique. Oh wow, that should be great.
Yeah. So that's going to be, and I think it's J6 or J6 related. So that's going to be really good.
So subject matter expert there.
Yeah, right. Yeah, the guy went to prison.
I know, right?
So we've got Enrique and Vince locked in. Still looking for someone for you to debate. There's a chance. So Not So Erudite's husband is a debater, but he doesn't have time to debate very much. But since she's going to be in town and he's coming down, he's looking for a debate. I got to look at his style. I've never seen him debate, but that may be something for you to
I'd take it. To be completely honest, if it's not something I'm going to just pile drive the guy, that's fine. I don't want to pile drive the guy.
Yeah, I don't. I got to check his game film and see where he's at.
Sounds good.
But then we have a lot of people that are reaching out. Like there are way more people reaching out than I have places for, and so I've told people, I'm like, yeah, I mean, that's cool and all, but I don't know if I got a spot for you, bro.
Right. Right.
I mean, we've got guys that want to, there's a dude that wants the polygyny argument.
Good for him.
Yeah.
Is he Mormon by any chance?
No, I don't know. Actually, I don't think so, but there's a polygyny undercurrent out there these days.
There's a whole polygynous community.
Yeah. Well, beyond Mormons, I mean, like,
I mean, in general. No,
yeah. There's a whole bunch of dudes out there that think, think that they want that. But it's going to be an interesting debate. It may be that we have Father Joseph, who was at the event.
Oh, I loved him. I've spoken with him once briefly. He's one of the most intelligent. He's also one of the most intelligent people about theology I've spoken to. He's very good.
Yeah. So we've got, like I said, there's just a ton of stuff. It's just so crazy right now.
Star-studded cast.
Star-studded. We've got the venue. Although the venue is normally by now, I mean, the venue's, it's locked down, but it's not locked down because the people who own the place are too busy to get me the paperwork so that I can sign it and give them money.
You don't have a firm contractual agreement yet, even though you have a verbal.
Yeah, we have a firm commitment. They've said, yeah, it's available. We want you in there. Everything's good to go on our end. But what I don't have is I don't have that contract, and I don't have that.
You don't have signed, sealed, delivered. No, yeah.
Yeah. So, and I was actually supposed to have a meeting with them today. It seems like that during the day they're just wrapped, and they always want to reach out at night. And at night I'm usually wrapped. So
right,
I've got to.
We got to make that connection happen. Yeah.
For sure.
Sounds awesome. No, I'm super excited, man. Like, let me know again. Like, you know me, like, more or less what I stand. I'll debate more or less whatever, as long as it's not Trump bad, because it's retarded.
Oh no, I'm curating these debates.
I know you wouldn't do that.
I am definitely curating these debates.
It's a running joke.
Yeah, well, it ought to be, because like what the like you
tell me about that.
I told you. And then I've got. There's just a lot going on with this event. It's really like, for how quickly it's coming together, it's just off the chain.
One thing too. Sorry, related but unrelated, because it's also kind of a co-thing with Word War debate. I put my Word War debate audition up last night. So if anyone wants to go out there on X and find it, I made a good argument about federal supremacy clause and ICE. So if anyone wants to find that and like it, I think they'll get me into Word War debate on the next go round. So I just did that last night on a whim.
Yeah.
Yeah. Sorry.
Yeah, I think they're really going to be watching who's at this event.
Say hey.
Yeah.
Yeah. No, it sounds good. But yeah, so no, it's gonna be a great event. Again, at the end of it all, there's gonna be a little time there'll be a cash bar there, not open bar. We don't got money like that. And we won't endorse any lectures, by the way.
Stock bar too.
Stock bar. We got Johnny Walker, got everything.
Stocked.
But also then at the end of the whole thing, after all the debates, there's gonna be 3 stand-up comics, 2 of which I think are debaters, and 1 of which is local.
We're trying to find a local guy. That's the hope. And then at least one of which is a debater. We have 2 people that debate. So one of the guys actually was in Word Wars debate. He got eliminated in the first round, and he's a comedian, and he's coming to Nashville, and he just really, really wants to be a part of it. And we're like, well, brother, we got you.
Yeah,
we got you. You just come on in and do do 20 minutes for me, man. And so that'll be cool.
So it should be a good cap off to the night to decompress and everything, and then people can,
I think so. I think it's going to be one of those where it's like, it's just going to be so cool, that everybody's going to be really happy with it. And
I'm super excited, man. Since you started mentioning it, I've been on board. It sounds freaking awesome.
Yeah. The 30 tickets are available. The raffle or whatever we're calling it, that's all live. Everything's good to go. And so it's ready to go. Yeah, well, he steps away. Yeah, if you guys want to show up, the only way you can get.
I'm just wondering where my family's going.
Yeah.
No, they're leaving. They're going to Dollar Tree.
Oh yeah,
to buy Snickers bars.
My kid loves to go to Dollar Tree for all kinds of weird shit.
I know. They're like, apparently they're going to go buy Snickers bars.
Oh yeah.
I'm like, okay. Anyways.
Yeah, my kid loves a dollar store. He's like a little he used to get just all sorts of random, like weird small stuff.
Right. Like this, like a squishy dinosaur, like a Jello dinosaur, and like an old Easter egg candy from 3 years ago. Yeah.
Yeah. That's the kind of things I have there for sure. But no, I'm going to make sure that you get a very good, debate opponent, because ultimately it's got to be a good show. It's got to be a good time for everybody. And that's what's got to happen. So
no, it sounds good. Awesome. If Erudite's husband stacks up, do you think? I'm happy to debate anybody who's good faith, and you know that you see my shit.
Yeah. No, so the question is like, so we have enough debaters that now we're looking at. Okay, so we're gonna have this. We're gonna have the J6 debate. right?
Mhm.
And then we'll have probably one or two more political debates,
Mhm.
and then we're gonna have the girl debate, right? Because we got to have the girl debate. Then we'll have the
I need something.
Wave, you're on camera.
we're gonna have the
No, I'm not the one.
what is it?
You can
You need the what now?
cash that card.
You my Cash App card?
No, like, I don't know what, like,
Hang on 1 second. 1 second.
right.
Go ahead, Grid. I'll be right back.
All right, yeah. So we're gonna try and have as many of the
I'll bring it up. Go ahead. I'll bring it up.
normal type of debates, but I sort of categorize them into like social issues.
Sure, you can bring it up.
So you got social, political, philosophy, and just various genres of debate. And
Yeah.
so, like political philosophy, I think is one I think that is underutilized. So I'm waiting for that. Like we've seen.
I can. I can do that, and I can do.
Yeah. And it's kind of becoming a thing, where people are like, what's the argument for being a Democrat, right? In this world in modernity, why would you not be a conservative? And
right, or anything like I can also do anything obviously like legal philosophy or like legal political as well.
Yeah. So it's just so basically I defined a sector, and then I defined a topic in that sector, and then we find the people to argue that topic. That's how I do it.
No, I mean that's the best way to do it. That's why you don't end up with some of the like.
And there's a little bit of manipulation involved too, because what I normally do is I'll be like, well, I'm going to get like two guys that are known to debate politics,
mm-hmm.
and I'm going to put them together, and I'm going to say, okay, get a topic about politics. The whole time I want a Trump bad Iran war, topic or something like that.
Right.
And then I just let them figure it out. And they usually, it's a little bit manipulative. I'm definitely playing the odds because it's easier when people come up with their own topics. Even if they've been pushed in a specific direction.
Well, I can speak to that with the two debates you set up with me and Bones and me and Vince. Is we kind of like here's his background or whatever, and we generated our own topics for those debates.
Yeah. And it works out really well because it's still the subject I want debated.
Yeah, exactly. But it's just like
it's still the subject I want to debate it.
But what specific nuance of that do they want to actually tackle?
Yeah. Where do you guys want to take it? Right. So it's gonna be awesome. I can't wait to get you guys on the show and let you guys have a great debate. I feel like you are kind of owed a good debate.
I appreciate that.
I did see that your debate was reviewed last night. I haven't watched it, of course, but
I've seen people who've watched it who said that I haven't watched it yet. I'm fitting to watch. I'm not. I think it's kind of. I mean, I'll watch it first, but I don't think it's really like good form to review the review unless there's something like to take away there. Like I know I give constructive criticism. I like constructive criticism, but from people I know who actually watched it were like the review was more of a mess than the debate was. I'm like that's hard to imagine.
It is kind of hard to imagine. That's very interesting.
That's what I've heard from people. Again, I'm not trying to pull the Candace Owens and say, "Oh, it's true," but I mean, I got to
ask you. You watched the Candace Andrew debate, right?
I reviewed it actually. I have a 4-hour live stream. I reviewed it all and broke down all the legal arguments. Yes, sir.
So where were you at on all of the? Let me give you my position first, and then you can tell me how wrong I am.
Sure.
I felt like, or no, my observation is not feeling. My observation is that Andrew was trying to lead Candace into specific positions to take. Mm-hmm. He was also giving out information in a fairly concise and what's the word I'm looking for? A very concise and very practical way. Very
digestible way.
Yeah. It's very practical, very common language. Candace seemed to be constantly pivoting and constantly trying to tell a story rather than just break down what actually happened. It wasn't concise answers. It was always like, well, back when blah, 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 blah.
Right.
And that's my lasting takeaway from it. I mean, it was like 4 hours long, so I didn't.
I reviewed the whole thing from start to finish.
Wow.
So here's one of the people who watched the review, and this was their approximation of it.
It was very meh.
Yeah. Apparently, the person who reviewed it, AVG, is a big friend of Emmett's too. So that.
AVG, they work together.
Yeah, that's fine, and that's good. Good on them. Like no shade there. And I get biases. And again, like, I mean, as far as my opinion goes, is the takeaways from that debate. I posted a video of this to my YouTube. It's only a 5-minute one. It's my first cross-examination of Emmett. Like, I think it was.
I was talking about Candace and.
Oh no, I know we were, but this was about the review about.
Oh, okay.
Sorry, chat popped in, so I derailed.
Gotcha.
I'm sorry.
I got you.
I think my cross-examination of Evan was very good, and kind of as far as the debate devolved from there. But I think if you just look at that cross-examination, like the position was destroyed in that 5-minute clip. I posted it. If you have an extra 5 minutes.
Yeah.
Okay, back to the Candace and Andrew thing. Okay, so here's the thing that I really took away from that is, so I also know the prompts that were agreed to in order for the $300,000 payout, right, was that Andrew was required to assert that he had reason. I forget, like a 75% certainty that Robinson did it, and that Candace was then expected to assert to a 75% probability that Tyler Robinson was a patsy, and then defend her claims as to why. Yeah, and so the first part of that happened, I think. Andrew did a very good job so far. And the thing too is that the thing that annoyed me and I got off on in my review of it all was that Candace said a bunch of stuff that is legally untenable. Like the whole review is hearsay, so it's equally as valid. I'm like, no, it's not. And she purposefully
did that.
I know.
She you know what? I don't know if you caught this. She defined what hearsay was. Kind of wrongly.
Well, what she said was the entire 1102 hearing is hearsay, which is completely.
And Andrew corrected her and said, no, hearsay can be put in this hearing. And
cool. Yeah, I like. Sorry, real quick. I like AVG and Emmett too. Emmett's been cold to me since I've debated him. I've reached out to him. I have nothing against him. I just think he has a very bad moral position, which is okay. Sorry, go ahead.
Oh no, no worries. So. Candace, just my observation.
Go ahead.
I think that she was purposefully being obtuse and basically shotgunning the whole thing because to actually say that no, a lot of this is not hearsay, but hearsay is allowed, and to admit that it damages her position, and which she should have just accepted that and just said, yeah, I know that. I know what it is, and I don't care because it's weak.
And I think she counted. I think she counted on the fact that her millions of subscribers don't know and don't care the differentiation.
Well, they're not going to look.
Right. And so, like, again, like, I mean, and I went through this specifically in the statute in my review of it. I brought up the fact that, okay, so like when you have the officer who interviewed Tyler Robinson's parents, and you're putting in his report of that into the court record, as opposed to actually calling his parents to the stand, that is hearsay. So he's telling you what Tyler Robinson's parents said. That is hearsay. The DNA evidence, the video evidence, the fingerprint evidence, the text message evidence, that's not hearsay. And that will all be admissible at trial because it's the text messages are what's called a exception to hearsay for statement against party interest. So since Robinson made them and they can be verified, the whole thing is they've already been verified because the fact is that the state could not enter them into evidence even at a preliminary hearing without them being authenticated. If they would have tried to do that, the defense would have had to object. They didn't. So those are authenticated. Those will go into the final trial as is. And so those aren't hearsay either because they're statement against party interest. And so at that point in time, like, yeah, the police reports are hearsay. But other than the people, the officers who were saying what other people told them, the vast majority of the evidence induced at the hearing was not hearsay. There were hearsay elements, and hearsay is allowed at a preliminary hearing because the bar is so low. But that's it. And so when she started off with that by saying that the 1102 hearing is all hearsay, I was like, oh, here we go.
Right. That's true. So I just feel like that. Well, again, my observation is that every time Andrew would answer honestly, Candace would pivot.
Yeah, she'd run away. Yeah,
and obfuscate. And try and tell a story. What Candace was really doing was Candace was trying to tell a story, trying to merge her viewpoint in such a way that it obscured the facts that Andrew was putting out. Yeah. Andrew was very careful, it seemed to me, and I could be wrong because I don't know the facts. I haven't paid a lot of attention to this beyond the arrest. It seemed to me like Andrew was being very, very careful to be very, very honest about the facts he was putting out. And
so I know for
when he said when he wouldn't be clear if it was a fact, he'd say, well, my understanding is, or this is what has been reported, that sort of thing. He was very, very careful with the language he used. Mm-hmm. And I think Candace was not.
Well, I would disagree with that. I think Candace was very, very careful with the language she used to avoid having to actually admit she's been making shit up. So, I mean, I think they were careful with language in very different ways. Andrew was careful to make sure that his factual record was correct. Candace was very, 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 very careful to dodge any necessity to substantiate anything through facts. So
fair. That's
my ultimate analysis. Is that's how it was. And he tried to. Well, you said this thing about French Foreign Legion, and she's like, "Well, I have sources, but I can't reveal them because I emailed Donald Trump and he hasn't responded to me yet." I'm like, okay, well, that proved again, like that could be true. That's fine, but that's not answer to the question of what evidence do you have the French Foreign Legion was involved. I have a source I can't name, and I know it, and I'm certain enough of that belief that I emailed Donald Trump, and he hasn't gotten back to me. So that's proof of the fact that what I sent him was true.
Yeah, I think it's all weird, right? Like it was just a bunch of nonsense from Candace, and it was very carefully curated wording from Andrew.
Oh, I think Rasslin wants to back in. Hey, Rasslin, what do you think?
Do you remember her reasoning as to why, her reporting it was evidence that she was reporting what she believed to be true?
I mean, she gave several. So regale me with what you think is the one you're thinking of.
Yeah, she was saying that because if she knowingly lied to the police, and they could come after her for it. But the thing is that's exactly why they allow reliable hearsay in the hearing, because if you knowingly lie during the hearing, they can come after you for it.
Right. Especially because all the reliable hearsay testimony in the hearing was from officers, like police officers. If you falsify something on the stand, even in a preliminary hearing, your career as a law officer is done. You go on a Brady list and you can face imprisonment.
Yeah. Yeah. Look, ultimately, I think what Candace's goal was to continue to put forth the narrative that Andrew's paid by TPUSA, that he doesn't believe what he's saying, and a bunch of things that have nothing to do with this court case. Honestly, I don't think that she doesn't want to address the court case.
No,
on its face, because
on that same side, I think that on that metric, right? I think both of them got out of the debate what they wanted to get. I think she ran around enough that she gets to continue her narrative without too much scrutiny. And Andrew got out the fact that she really has no evidence to back up any of these claims she's making about any kind of collusion or Patsy or Israel or French Foreign Legion or whatever. So I think they
were the Egyptian jet
or Egyptian planes or the exploding pager or whatever. So I think they both accomplished their goals in debate. If it was a debate about the facts, I'd say Andrew won because Candace didn't offer any facts. But if you're like, did they each achieve their goals? I think they both achieved their goals.
Sure. And I would agree with that. I agree with that assessment. Yeah. Yeah.
Rasslin, what do you think?
I honestly think that Andrew lost, unfortunately. Not in regards to just his goal. Like if his goal was just to expose she has no evidence, then he won in that regard. But I think him allowing Candace, like I've never seen Andrew debate like that before. He allowed her to avoid like obvious like concessions and just obfuscate over and over and over and over.
I
again.
think there was, and I think Rob Noor did
So it was in the contract.
Yeah, I think there was like Andrew couldn't do X, Y, and Z like once she said something, he had to accept it, and that was part of the contract of the debate. Rob Noor did a stream on that the other night with Ryan Mullally, I believe. So I don't disagree, and I think that's the same thing too. Is why I think like they both got what they wanted out of it is because the terms to allow it gave Candace a lot of leeway to do that. I believe that was specifically negotiated, actually.
Right, and that's one of the reasons it's going to be an interesting thing because, and I'm going to have to jump off here in a minute, but it's going to be an interesting thing because at some point this contract's going to be leaked.
That's fair, Varen. That's fair.
Yeah, I think that's true too. The whole contract's going to be leaked, and I think it's going to be very bad for Candace. She's already kind of damage controlling now.
Yep.
And talking about how unprofessional Andrew was and blah blah blah. Well,
right,
look,
his team or whatever.
Yeah. So here's the deal. Andrew is an entertainer on YouTube. He's very professional for being an entertainer on YouTube. I'm not surprised that that in her eyes, having worked with with syndicated networks and whatnot,
Turning Point, Daily Wire, and all them. Yeah.
Yeah, I'm not surprised that she found that to be somewhat maybe not as professional, but I also think that she's blowing everything out of proportion.
It's part of the grift. It's part of the grift.
Yeah, it's part of it. And she kind of has to say that because if she says anything that's really too complimentary, then it ends up hurting her.
Yep. No, I agree. And the thing is, even if we have the law of diminishing marginal return, like people are going to catch on that she doesn't have evidence, right? She has 6 million views on all of her videos. So after this, if it drops to 5 million, and then in 6 months it drops to 4 million, and in 3 months, there's still plenty of income. She's already a made woman in that way.
Right. Well, and again, I just find the whole thing interesting. I got to get out of here.
And you're fine. Take care. You're good. I think we'll close it down. I think I'll do an hour debate review later on, maybe if anybody's up to watch me make fun of spoken word poetry.
All right. See you guys.
Hey, take care, Grid.
See you.
Hey, Rustin, any other thoughts on stuff now? So that was kind of like a complete segue from what we were talking about.
No, man. Thank you for going over it, man.
No, absolutely.
I've been trying to bring attention to this doctrine, to be honest.
I'm aware of it. I'm just waiting for something to happen to make it more concrete. I appreciate you, man. I think you and I probably agree on 90% of things, which is good. And
I heard you're a Kierkegaard fan.
I am a huge Kierkegaard fan. Yeah, I did my master's thesis and part of my dissertation on Kierkegaard and T.S. Eliot.
Really, that's cool.
Yeah.
So you like the Kierkegaard specifically, or just existential literature?
Oh, I love existential literature in general. Kierkegaard specifically, because I think as far as we're talking about moral philosophy, I think Kierkegaard is much more coherent, even though he has written. Also, the guy's a fucking G. He wrote 38 books before he died at the age of 26. The guy's a freaking savant. But I think his moral philosophy, if you can get through the craziness of it to actually get to what's at, I think is better than any other existentialist philosopher. I'm a Nietzsche fan. I'm a Camus fan. Sartre rubs me both ways at the same time. I'm a huge Dostoevsky. If you want to call Dostoevsky an existentialist philosopher, I love him too. If you want to call him an existentialist literate, I'm fine with that too. I like Pushkin. I like Gogol in that same vein. Solzhenitsyn I would also call a existentialist writer.
Yeah, we might have to talk about that at some point.
Go ahead.
I love Kierkegaard. But I'm not as big a fan of his philosophy in general.
he definitely didn't like system builders, and
No, he was an anti-Hegelian, and I'm also an anti-Hegelian at base, which is why Chapringu and I butt heads all the time.
Yeah, no, I am a system builder at heart, like a Thomist, so
Yeah, no, that's fine. No, I don't have any problem with Thomism. I just think that I guess my problem is basically that the system that Hegel built is so fundamentally flawed it led to the First World War, is my claim.
yeah, I think Kierkegaard would actually go farther and say all systems are flawed. Like
That's possible. Yeah.
Like I think he has this quote where it's like, the system builder makes this giant castle and then lives in the shed outside.
Something like that. Yeah. I mean, Dostoevsky does a similar thing and says like for the socialist, the communist, or he doesn't say social, for the people who believe in the glass castle on the hill, they imagine a glass castle of ants. And if you're not and so I mean, I think Dostoevsky takes it farther in his literature. Like he never wrote any philosophical tracts, right? But I think Dostoevsky's critique in Notes from the Underground, which is where that quote comes from, which we'll get to in the next Natural Law Book Club. Actually, I think Dostoevsky in Notes for the Underground makes one of the most both literarily and like humanly cogent critiques against systemic philosophy. Well, a systemic philosophy of the left, I suppose.
Yeah. I just think that from what I've read on Kierkegaard, and I definitely haven't read.
So, what can I ask? Can I ask what you have read? That might help me understand. I'm sorry.
I've read Fear and Trembling actually.
Great book.
Recently. Sickness Unto Death, and then it was a while ago, but I believe it was Either Or was the other one.
Yeah, that's good. That's good. I think so. I mean, and this is going to be a huge homework assignment. I'd be happy to discuss each and every one of those with you. Where he really gets into his attack on systemic philosophy is called the unscientific conclusion. So the unscientific postscript to philosophical thoughts, 2 volumes.
Isn't there one also called Philosophical Fragments? I remember starting.
Oh yeah, you're right. Sorry, yeah, you're right. You corrected me. Yeah. So there's Philosophical Fragments, and there's the unscientific postscript to Philosophical Fragments, which is 2 volumes. So it's funny that he's such a funny guy that the postscript is 2 volumes of the same length as Philosophical Fragments, which was 500 pages by itself.
Yeah. I have not read the full thing. I remember starting it and then being interested in something else. But yeah, Fear and Trembling was very good. Fear and
Trembling is fucking brilliant. So is Sickness Unto Death. In my master's thesis, I mostly focused on the concept of irony, which was Kierkegaard's master's thesis, and then he does a very good breakdown of Socrates and why Socrates is so important. He doesn't really assert any of his own philosophical principles in the concept of irony, but he does a very good analysis of Socrates for the modern world, I would say.
Oh yes, that's also something I've read.
Cool.
For schooling, I read his doctorate, his thesis statement for his doctorate. That was
maybe it was. I think they were the same thing back in the 1800s. But the concept of irony was what came out of that.
He wrote his entire thesis for his doctorate on Socrates.
Yeah.
It was like super fucking long, but we were doing a project on Socrates, and I decided to analyze what Kierkegaard was saying.
Hell yeah, man! Way to go above and beyond. Fuck yeah.
Yeah, I think Kierkegaard's analysis of Socrates was good.
I think so too. And I think also if you want to pair it with because Nietzsche was all about the Greeks in a completely different way. So I think a good comparative. I don't think anybody's done it yet. At least not in the literature I've looked at. I'm kind of plugged into because before I did the lawyer thing, I was a literature professor and philosophy professor at University of Texas, and so I was doing a lot of stuff with existential philosophy and literature. Taught Kierkegaard, taught Nietzsche, but I think Nietzsche's love of the Greeks is so different than Kierkegaard's. That's very interesting to look at them in comparison at some point in time.
You were a philosophy professor?
Yeah, and literature and philosophy of literature.
Oh, okay. So did you get a PhD in philosophy, or did you get?
I got a dual PhD from Emory in philosophy and literature.
Oh, okay, that's cool. That's cool. I didn't know that. That
sorry.
awesome.
Yeah. That's a lesser known fact about myself.
Yeah, I'm actually pursuing a PhD in philosophy. So
Cool. Can I ask where at? If that's not going to dox you or anything.
I'm
Fine.
trying.
That's fine. Don't worry about it. Don't worry about it. Don't worry about it.
No. The reason is because I said I'm pursuing it.
Oh, okay.
So,
okay. I got you. No, you're fine.
yeah.
That's cool, man. I mean, do you want to teach one day or just like be more informed, or what do you think?
My end goal, like if I could have exactly what I wanted, it would be an R1 position at a university.
Oh, cool. That'd be great. Yeah. So for everybody who's all like about, so I first went to the Marine Corps and did Arabic linguistics there, got a certificate from DLI in Arabic linguistics, and then did human intelligence stuff. At the same time, I also did an AA in philosophy from Monterey Peninsula College. So then did the whole Marine Corps thing, got out of that, went to the University of Wyoming, did a bachelor's degree in English literature. And after that, did a master's degree in English literature from University of Wyoming, and then a PhD in literature and philosophy, dual PhD at Emory University in Atlanta, and then did an MFA in creative writing poetry from University of North Carolina, Greensboro, and then taught at University of Texas. So that's my whole academic. And then after COVID, and then they were like, oh, you don't have tenure yet, so fuck you, go away. So then I was like, well, I better go to law school then. So then went to law school at Ohio Northern and just finished that in 25. So I've been around the block, as they say.
Okay, yeah, I didn't know that, but yeah, that's my primary criticism of Kierkegaard is just that, like, I think he was too committed to the
all along
idea,
the way, Okale, all along the way. Sorry, I was responsive in the chat. Yeah, I mean, and I can understand that, but the thing is, like, when you're fighting against Hegel and like the German war machine, like the German pre-war, like statist pre-war machine, like maybe some access against that is the right balance.
Well, yeah, I mean, I could definitely see that. Hegelian philosophy definitely is like
It's problematic on its face.
Yeah, right. But the thing is like when you overbroaden it to include all systemic philosophy, and then you take this like almost, I'm not gonna call it nihilistic because it's not, but like
True.
it's kind of a nihilistic outlook, at least on truth, where you're like embracing the paradoxical and accepting that like
That's so fucking sexy though.
No, like I don't think so. I don't think so. It does. It's not sexy to me. I don't.
Man, we need to say. I think we're probably, like you said, running off the rails here with this live. But man, we need to set up a time to do like a deep discussion about that. I'd love to talk about that. That sounds awesome. Like the thing about it too is I think that like because Kierkegaard was trying to do something that Hegel didn't do, which was somehow incorporate the aspects of faith and a human fallibility into his world system. And so if you're going to say that, like Hegel says, right, I'm not saying you're a Hegel defender. I'm just saying, like, Hegel says, like, there are impurities or imperfections in our knowledge, but through the advent of human technology and our progression towards the historical absolute and the elimination of lesser species, lesser races who don't, like, are not on the technological train with us. If you're not as advanced as we are, you're lesser, so go away from us. And we'll advance to the absolute knowledge of the historical ultimate, right? Then, because that assumes that through the dialectic and through the other historical processes that Hegel, in the philosophy of history, in that whole fucking tome, he goes through why we can use the same logical principles of the dialectic to apply to the way history is progressing and predict the future based upon our more intimate knowledge of science and our technological progress. And we already know what we need to know, and whatever we don't know, we're going to figure it out later on. And that's just the course of history. We're on a straight shot there. I think introducing some notions of the paradoxical and how human nature is inherently fallen, and we need to second guess ourselves if we think we're right at every turn, might be a helpful antidote.
Yeah, that makes sense. I think we should talk about this.
I would love to, man. I'm super excited. This is awesome.
Yeah, I am a Thomist, so like that's what most of my philosophy.
I have nothing against Thomism. I mean, maybe if you want to shoot me something on Discord about like your are you like a strict Thomist, or you have your own personal, like if you want to shoot me like a bullet points of like what you think like of your Thomist interpretation, your Thomist viewpoint, I'd be happy to like see if I have a Kierkegaardian response. I might not.
Yeah. There's Thomism, as I would define it, and I think others, is just like a set of principles that can be applied universally.
Okay.
To figure out questions or answers to questions that you have.
Does
about-
Thomism? Okay, so in your version of Thomism, is there like allowance for divine mystery, or like the of things that are beyond humans' comprehension but yet are real?
Yeah. So Thomas actually goes into this specifically.
Right.
The divine mystery, the thing that's incomprehensible, is the divine nature itself.
Sure.
And the only way that we can actually relate to the nature is through these what's called Cambridge properties, which aren't like properties of God, but properties that are ascribed to God through relations.
Sure.
And so that is how we come to know God, but we can't like understand or comprehend his actual nature, intrinsically.
So and I think we'll probably leave it on this because I don't want to get too far in the weeds, even though this is fucking super interesting, right? Well, I'll let you respond. I'm not going to just cut you off. But so when Kierkegaard in Sickness Unto Death talks about how the self is not a self, and that's I think what you saw on the Discord about what made you know I was a Kierkegaard fan, was that bit in Sickness Unto Death where like the self is not yet a self. It's a self that relates itself to the self and to the divine unity. And only in that relation to the divine unity and that divine identity is actually a self in that positive third of those relations. And so from a Thomist point of view, if the divine identity can't actually be known, right? I guess you have to accept Kierkegaard's premise then. Like how can we know ourselves? Because part of our nature is divine, is in the image and likeness of the divine. Like without giving that, how can we know ourselves without knowing our relationship to the divine if we don't invoke the paradox?
I think I'm hesitant to say that anything about our nature is divine. Is where I think I would push back on. Yeah, but we can get into this. This is a very interesting conversation.
No, most definitely, man. And that actually too, for anybody who's listening, who like when I took up the anarchist position against Emmett, right? It's kind of bounded in this idea of like not knowing we know. So like my anarchist position, like I've said to other people, is very much like Michael Malice's, like only voluntary interactions should be the government. And if we want to voluntarily interact to elect ourselves an emperor, that's fine. But the emperor doesn't have authority over us, absent our voluntary choice of that, absent our voluntary low-level interactions, right? So, but that goes back to the whole paradox thing in nature and everything. But that's neither here nor there for now.
Yeah. Well, you have a good day, man.
Hey, you too, man. It's always a fucking pleasure. I'll look forward to hearing from you later, man. This sounds great.
Yeah. All right. See ya.
All right. Hey, everybody in the chat, take care. I'm bouncing off now. I might be on later for an owlish review stream. It should be lots of lulls. Take care, everybody.